Yeah, there is motion. Motion, I think you mentioned item number 7. I think it's somewhat, this may be the last set of it.
But this is long pending, 2024.
Also, here, I have some problem here in this matter. Well, the report, the file was missing, all the rest I have recovered. Because I have already received the instruction from this department. So 2 weeks time is granted. So they enable me to file the affidavit of motion.
Okay. Which is represented on the prayer made by under additional application for the state list after 2 weeks. Interim order passed today is extended till the next date of listing.
Lordship, I have to mention, I can share for the Lordship. Lordship, this matter is fixed for admission ready today, Lordship. However, counsel for the petitioner, this is alia is grateful today, Lordship. So I short recommendation may cannot be granted.
3, 4, and 5. Both sides are represented. As the learned counsel holding the brief is in bereavement, the matter stands adjourned today. List after 2 weeks.
Objection.
This Lordship, Lordship, I want to mention item number 12. Lordship, in this matter, I'm yet to receive instruction from the department. So can you grant 3 weeks time to file the counter? To receive the instructions.
Both sides are represented. One last opportunity of 3 weeks is granted to the learned on the prayer made by learned additional learned additional advocation for the state. 3 weeks. Time as the last chance is granted to the state to file affidavit in opposition with the matter.
Which one need to receive the instructions? So can we please
No, but-
not last chance will not be
No, the which department?
medical also.
Medical.
Yes.
It is made clear that if the medical department does not provide requisite instructions to the learned advocate general within a week from the date of the order, the next date of listing, a court may pass orders for personal appearance of the head of the department, along with all the concerned officials and records, to assist the additional advocate general for the state to respond to the court queries. Next paragraph, the learned additional advocate general shall send a downloaded copy of this order to the head of the department, head of the health department, to bring the order to the notice of the said authorities. List after 2 weeks, 3 weeks. Okay.
Mr. Lordship, I need to mention item number 26 from the orders column. Here, we have taken steps in the sole respondent. However, this is the first time the matter has been listed after the notice was issued. So, if this matter can come off after 3 weeks or not.
Is the service complete? No.
Lordship, we have already taken steps through registered post.
What is the-
8/4/26, my lord, I am not very sure about I have not checked the office note, my lord. We've taken steps on 8/4/26.
Okay. As the learned counsel for the petitioner submits that on 8/4/2026, steps has been taken. Full stop. As per office note dated 9/4/2026, return of service is awaited. Next paragraph, list after a week. Full stop. In the meantime, the office shall put up a note regarding service list after a week.
Should this be interim?
Interim order passed today stands extended till the.
Yes.
Just a moment. What is the stay?
Worship, if worship, you kindly produce the order 7/4/2026. Worship in the 10 last paragraph. Meanwhile, the order restraining the petitioner by entering into his present residence is stayed till the next date of his stay. The last paragraph of the order.
But then you should serve notice by way of the stay, because this, you see, this injunction, unless served on the other side, is non-effective order of the court.
Then worship, if I may be allowed to take custody service.
You'll have to do it. Otherwise, this the order will be a paper order. Doesn't help you.
Worship, if I may be allowed 2 weeks then to file my to take custody service.
Okay. Before the last time, you said, in the meantime, on the prayer made by learned counsel of the petitioner, the petitioner is permitted to serve notice on the respondent by way of dasti by routing the process through the registry of the court, and after service, an affidavit of service and filed prior to the next date of listing. This started 2 weeks.
Worship.
Maybe it's my Lord, I'd like to mention item number 6. My Lord, I have taken the concern of the opposite party and I have appreciated this matter will be fixed on 12. It is coming Tuesday.
Okay. Consider the other side. The learned counsel for the petitioner pays for adjournment pays around based on 12/5/2026. Okay, just record the present resolution. Okay.
Like this, Worship, I'd like to mention item 21. Item 21.
Yes.
If I may be allowed 3 weeks time, the Worship to file my contract review.
This private respondent also here. Notice is served on them. Huh? Only government. Okay. Okay, both sides are represented on the prayer made by Mr. Nagaland and Senior Government Advocate. List after
3 weeks.
3 weeks, so it's available to file affidavit in the matter. Next paragraph, the registry shall reflect the name of Senior Government Advocate for the respondents while listing the matter next.
There's an interim.
Okay, interim order passed today stands extended till the next date of listing. List after 2 weeks.
I would like to mention item 23 on behalf of my colleague Kian Rami Alonche. I told he's presenting respondent number 1 and 2. And respondent number 3, 4, and 5 are private respondents.
Is notice served?
Yes, worship.
Yes.
23. You want how much time?
At 3 weeks time, Alonche.
3 weeks.
3 weeks, Alonche.
No, service is awaited. The Learned Counsel for the petitioner and the state are represented on the prayer made by Learned Senior Government Advocate. 3 weeks time is granted to file affidavit in the matter. Next paragraph. Service of notice on respondent numbers 3, 4, and 5 is awaited. What is this? By speed post is awaited. Sent by speed post is awaited. Look at this. How can we accept this to be notice served on respondent number 5? Just show this. This the name of the respondent number 5 is there in the last page. You see the name is in the last page. The name does not match. Name is Sri Doping. Signature is by someone K something.
I'll have to talk to the.
No, last time we took, on your submission, we accepted the notice to be duly served. This order has to be recalled.
It is in the same village, one of the.
No, that we don't know. Your affidavit says it was served on Mr. Doping.
Yes.
But this is signature, this handwriting is, the name in the signature is not Doping.
Allow me to ascertain the fact.
No, it's okay. It's okay. For this 5, we'll have to recall it. Next para on, though by order dated 4/5/2026, the court had accepted the notice to be duly served on respondent number 5 by way of Dasti, but on a perusal of the affidavit of Dasti service, it is seen that the name of respondent number 5 as appearing in the signature does not match with the name of respondent number 5. Therefore, the order dated 4/5/2026, insofar as acceptance of service on respondent number 5 by Dasti is concerned, the same is recalled. Next, the learned counsel for the petitioner pays for some time to obtain instructions. Next, in the meanwhile, the registry shall put up a note regarding service of notice by speed post with AD. Next, list after 2 weeks.
And allow me to find Mr. President, explaining how this was. This service was.
You do it first. You have your instructions. If your person says that it was not A but B, then you'll have to take fresh steps. Your affidavit will not cure that.
You go. So we will go with the internet.
Okay, interim order partial list and is extended to the next date of listing.
Thank you, Your Worship. Project of the council 1998. What is the getting proposing this mentioned? So the matter will be listed fixed on 25th of May. Prohibition hearing.
25th of May.
Lordship.
Okay, both sides are represented on the prayer made by learned counsel for the petitioner. List on 25/5/2026.
Yes, follow. My lord, in sentence 25/9, I received the evidence of the government before it's clearly. So I mean, taking some time to file my reply. This trips not.
Okay, all sides are represented on the prayer made by learned counsel for the petitioner. 3 weeks, at least after 3 weeks, so as to enable the petitioner to file reply, if so advised.
Please follow.
This Lordship, my lord, on behalf of Inaholia, I'm mentioning item number 27. My lord, I'm from the share stating concerning whether the matter be listed up in
27.
Yes.
Okay, what says represented? On the prayer made by the government advocate, list after 3 weeks.
My lord.
It's okay, we said
Mr. Worship, Your Worship, I beg the motion, I give to the
25.
Your Worship, we've already taken steps. We should notice.
Okay. Sorry, the counsel for the petitioner and the government are represented. The land counsel for the petitioner submits that steps has been taken for service of notice on the private respondents. Stop. Accordingly, list after 3 weeks awaiting service.
Your Worship, I beg the motion, item number 10. On behalf of now, please dispose. So if this matter is number of the votes.
Both sides are represented. On behalf of the learned counsel for the petitioner, it is submitted that the learned counsel is indisposed and therefore prayer for adjournment is made. Prayer is allowed. List after
4 weeks.
4 weeks. You are for the private respondent. Madam was for private respondent. You are for private respondent.
For respondent number 6, that
Your name is not there in the.
Option currently reflect my senior.
In this
Study Council of AG, London Generally.
Okay, the registry shall reflect the name of SCAG while for the respondent number 6 while listing the matter next. Okay.
Yeah, Mr. Lordship. I made a mention on item number 24. Beginning with number of for respondent number 3. Not here where you do receive an instruction, so if 4 weeks time available to me.
Item
24.
What says a representative on the prayer made by for the government?
Or for the union.
Okay. Prayer made on behalf of the learned CGSC. The matter stands adjourned today. Next one, the registry shall reflect the name of CGSC while listing the matter next. List after
4 weeks.
4 weeks. So as to enable the Union of India to file affidavit in the matter.
It's 3 weeks ago, it is for his also still meeting.
Wait, 4.
So,
okay.
First report on 31st April 2026.
Okay. Next matter, it is submitted that the the service on respondent number 4 is awaited. Stop. According to the next date of listing, the registry shall put up a note regarding service. Okay.
Bye.
Worship, I think the version I don't know what he did. Worship, I think this is after preparation, so I think I have to study the final clearance.
13.
Worship,
How much time?
3 weeks then worship.
Do you believe what you are saying? If it is in preparation, it will be within 1 hour, 2 hours, something. If it is 3 weeks, then you are not in preparation. Right? Yesterday I learned some art of cross-examination. Okay. Both sides are represented on the prayer made by the government advocate, list after 3 weeks. 14 also. Okay.
15 also worship.
15 also. You can say it in one go. Okay, 15 also same. Okay.
I 17 and 18 is from here. I did receive instruction worship. Here I did receive my instructions, so 3 weeks later, I will have to be after.
In this 18, who is the authority to give you instructions? In item 18, who is the authority to give you instructions?
DC local motion. Deputy Commissioner local.
Deputy Commissioner Okha. 17?
17 and 18.
17, 3 weeks time.
Oh,
Item 17, you say both sides are represented. 3 weeks time is granted to the state to file affidavit in the matter. List after 3 weeks. In item 18, you say both sides are represented. First of the London government advocate submits that she's yet to receive instructions from the Deputy Commissioner Okha. Next panel. As this is a as a lot of time has been granted to the state to file their affidavit, comma. The court is of the view that as the Deputy Commissioner Okha is not giving instructions to the London government advocate, comma, on the next date of listing. No, sorry. Unless an affidavit of the state is filed at least 2 days prior to the next date of listing, comma, the Deputy Commissioner Okha is expected to be personally present in court along with all the relevant records and be prepared to assist the London government advocate to respond to the court query. Full stop. The personal appearance would be dispensed only if the affidavit is brought on record. Next paragraph, the London government advocate shall transmit a downloaded copy of this order to the Deputy Commissioner Okha to bring the order to the notice of the said authority. List after 3 weeks.
Maybe this leadership, declaration and number 16. Item number 16.
16.
Yes, Lordship. The Lordship, we are able to file our affidavit. So please run 4 weeks.
16. Both sides are represented. List after 4 weeks as paid for by London Council for the petitioner.
Introduction.
For motion, item number 1.
I wish Lordship, petitioner is present for release of his payments and Lordship. Lordship, petitioner was appointed as a computer operator on fixed pay with office order dated 18/07/2027, Lordship. And from time to time, his service was extended, Lordship. Since his initial appointment,
Initial appointment was when?
18/07/2027, next week,
18?
18/07/2027. 2017, Lordship, 2017.
Please, 18?
18/07/2017. Since then, till 2022, February has received his salary, Lordship. However, from 2022 March till 2024 February, he has not been receiving salary. For which, Lordship, on 9/0/2026, I have submitted a representation praying for release of any salary, Lordship. However, the same has not been considered.
And Mr.
Declaring
O'Brien, Connect London Council for the petitioner.
Petitioner name is Siri Sangam. Siri Sangam. Name of the petitioner.
I have also heard you are appearing, Mr. Swenson, government advocate appearing for the. You are appearing for all?
Corresponding one.
For respondent number 1, and who will appear for number 2? Director would be the director's skill would be under the government. One for both the respondents. Next paragraph. The petitioner claims that by an office order dated 18/7/2017, he was appointed as a computer operator on fixed pay by the respondent number 2 and was subsequently attached to the REB, keep hire. Full stop. It is projected that though the appointment was extended from time to time, but with effect from March 2022, to February 2024, his salary has not been released. You're getting your current salary.
Lordship, I am no longer in service. I was not in service.
Okay, and thereafter his service was not extended. Just accordingly, by filing this petition under Article 226 of the Constitution of India, the petitioner is praying for a direction upon the respondent authorities to release his salary from March 2022, TO2, February 2024, which has accumulated amount of rupees 1,68,000. Next paragraph. Issue notice returnable on give a fixed date after 4 weeks. Returnable on so-and-so. Requisite extra copies of the writ petition with enclosures be served on the government advocate in course of the day. Next paragraph. The pendency of this writ petition shall not be a bar for the respondent number 2 to release the area salary of the petitioner for the period referred above. Next paragraph is non-payment of salary is alleged, the respondents shall ensure that by the next date of listing an affidavit of service shall be filed, affidavit in opposition shall be filed, filling which the state is put to notice that in the absence of any response, the court may invoke the doctrine on non-traverse and presume that the state has admitted the dues and appropriate orders shall be passed on the next date of listing. Next paragraph, request the government advocate to send a downloaded copy of this order to the respondent number 1 and 2. Put the state to notice. Next paragraph. List on 5/6. Yes.
For motion, item number 2.
Okay.
Wait, please, Your Worship, my lord.
Yes,
I am appearing item number 2, my lord.
you're there.
Motion. Sorry, I mentioned I didn't know it's 9 of the
Yes, Professor.
My lord, the matter is with regard to the CGST, my lord. My lord, as Your Worship is aware, under the GST law, the tax is leviable when the supply is made of the goods and services. Now, the taxable event is the supply of the goods and services. In the present case, relates to the construction of a bridge. Now, the bridge was constructed prior to 1/6/2017, although the payment was made after the coming into force of the GST Act.
Prior to which date?
1/6/2017, my lord.
But in your synopsis at page 2, you have referred the date of 1/7/2017.
I am sorry, my lord. I am sorry. 1/7. 1/7, my lord.
Yes.
Now, what has happened, my lord? The bridge are constructed on the instructions of the government, though no formal work order was issued, but the bridge was completed prior to 1/7/2017. Now, after 1/7/2017, the post facto approval was given and the work order was issued to regularize it.
Yes. This is on which date?
Well, post facto approval was formal work orders were issued on 24/7/2017.
Yes. Which is that page?
Well, this is page number 146. Now, my lord, when the payment was made after the coming to force of the GST Act, the tax was deducted as source. Now, on the basis of the tax deducted as source, the authorities are saying that the petitioner has suppressed the sale, the amount which was received in the returns, though in the GST Act, one return, my lord, after coming into force of the GST Act, the petitioner has shown the amount which was taxable under the GST Act and which was not taxable under the GST Act, which includes this amount. Now, Lordship, may kindly see one certificate which has been issued by the Chief Engineer, page 149, my lord. Yes.
Yes.
May I believe, Lord? This is to certify that so-and-so was awarded the contract for the construction of the so-and-so bridge under the department with reference to the ongoing proceedings concerning the taxable value reported by the executive engineer so-and-so. It is hereby clarified that while the formal work order was issued on so-and-so, the physical execution of the work was completed prior to the commencement of the GST law, that is 1/7/2017. The work was taken up before the formal issue of the work order due to urgent requirement of the bridge as per said bridge are in a main road connecting the parent district in the rest of the state. Work order was formally issued only after the work was completed and on receipt of the post facto AA form, the said government to prevent the project stagnation and to ensure public safety. The contractor was directed to mobilize and commence construction of via letter of intent and the verbal instructions during the year 2016-17 fiscal year. The formal work order was subsequently issued to the post facto administrative regularization of the work already performed. As the services were physically rendered in the pre-GST era, they are subject to the then prevailing WC work contract tax and service tax exemption for the government work, the other so-and-so. Now, my lord, the issue is that only, my lord, whether the work was completed prior to 1/7/2017 or after 1/7/2017. If the work was completed prior to 1/7/2017, the question of the imposition of the GST does not arise. Now, we made these submissions before the authorities in the so-called reply also, but the authority have not verified from the government whether the work was completed prior to 1/7/2017 or after 1/7/2017. In fact, I don't have the photographs of this.
Because in page 146,
My lord,
you will not find that it is post facto. This is in present, this page 146.
my lord,
It
this
could
is
be completed within 24 months.
my lord, I fully agree, my lord. My lord, what I feel, my lord, I made the government also a party. The government should come forward and file an affidavit to say that what is the correct picture, whether it was done prior to 1/7/2017 or after 1/7/2017.
In this aggregate turnover at page 116,
My lord,
chapter 5,
my lord,
I don't find that there's anything here
my lord.
says that the amount is in work in progress or something like that.
No, my lord, this was
It
completed.
is never booked.
This was completed, my lord, 2017, and we have mentioned
No.
that this is
That's why we are asking. You see, please come to page 116.
my lord,
Aggregate turnover period is from April to June.
my lord. My
But
lord.
in this set of documents, I don't find any.
No, this work was, my lord, no payment was received into 1/6/2000 prior to 1/6/2017.
No, but in the books, you have made expenditure. Let us say rupees you have spent. The
But
100.
in the return, my lord, I'm sorry, my lord, in the return, GST at 21, my lord, it does not, my lord, include the what work in progress or not. It's, my lord, when the work is done, then the payment when it is received, then it is become that period will be taxable. But if the work is executed prior to 1/7/2017, because the taxable event is the supply, the period at which the supply is made. If the supply is made, my lord, prior to 1/7/2017, then irrespective of the fact that the payment is received later on, my lord, it will not be taxable. So the question is that, my lord, when the supply was made. Now, my only submission before your lordship is that, my lord, the issue which is in fact which needs examination is whether the work was executed prior to 1/7/2017 or not. In fact, to my information, the bridge was also inaugurated prior to 1/7/2017. The bridge was also inaugurated prior to 1/7/2017, but I don't have the photographs and all those things. That will be in the government records. Well, the government has to file an affidavit and to show that whether this work was executed prior to 1/7/2017 or not. They have given a certificate. If the government because the bridge construction, it will not show that I have supplied some goods, something, and the goods have been whether it was supplied. There cannot be any confusion with regard to the construction of the bridge. Now, if the bridge was constructed prior to 1/7/2017,
Okay, we'll issue notice then.
My lord.
Heard Dr. Ashok Saraf, learned senior counsel, assisted by Mr. K. Nagi, learned counsel for the petitioner. Also heard for the state, you are appearing. For the union, okay. For the union, please record his name.
State also India, my lord.
Learned CGSC for responding number.
Standing counsel.
Mr. Standing counsel for responding number.
Number 1, 2,
1, 2, and 3. Standing counsel for 1, 2, and 3. And appearing for respondent number 4 and 5. Next para. The case projected by the petitioner is that the company had undertaken the construction work where is the description of work given?
Below the question. Description 146. 146 below you'll also find work for construction of the 6
construction work for, give inverted commas, construction of 6 numbers of RCC bridge within bracket 2 lane bracket close from Medzifema MEDZIPHEMA TO2 Jaluki JALUKIE Jaluki town inverted comma closed. Full stop. It is submitted that the bridge was constructed and completed even prior to the prior to 1/7/2017, even before the formal work order dated 24/7/2017 within bracket annexure Roman 6 was issued by the chief engineer, PWD within bracket R and B bracket close Nagaland. To support the said contention, reliance is placed on a inverted commas to whom it may concern bracket closed certificate within bracket annexure Roman 7 issued by the chief engineer, PWD within bracket R and B bracket close Nagaland. To show that the work order was ex post facto administrative regularization of the work already performed. Next paragraph. It is engineers are also very good authorities.
My lord.
They don't know how to write date. The state should supply calendars. No date, nothing.
Nothing, my lord, no date is there, nothing is there, my lord. Even I can fully appreciate, my lord. I was telling also that no date is there and the way the certificate is.
First thing which comes to mind is manufactured document.
My lord, in some states, my lord, they take it very casually, not manufactured, my lord.
I don't know. Full stop. However, in the meantime, the new GST regime had come into place, and accordingly, the GST authorities refused to accept that the work was completed prior to 1/7/2017, and resultantly, tax
only on the basis that the payment was made after 1/7/2017, and
on the basis that the payment for the work was made after 1/7/2017,
and tax was deducted at source.
huh?
And tax was deducted at source.
And tax was deducted at source after the GST regime had come in. Accordingly, the Director General of Goods and Tax Intelligence issued a demand cum show cause notice under section 74 within bracket 1 of the GST Act 2017 and Nagaland SGST Act, 2017. On 28/6/2025.
And finally passed the order in original below.
And thereafter, which was followed by an order in original dated 28/11/2025 by the Additional Commissioner, CGST, Dimapur, Commissionerate. Next paragraph. By filing this petition under Article 226 of the Constitution of India, the petitioner has assailed the said show cause notice dated 28/6/2025 and the order in original dated 28/11/2025. But the order in original, you will have to make an appeal. How can that be entertained?
Well, I can say, below the order in appeal is certainly appealable, but when the question of jurisdiction is there, if it is not taxable at all, then the question of 226 your loss will be aware.
That also the authorities can examine.
The authority can examine everything, below. There is no doubt about it. But the question of law, when it is there, whether it is taxable or not taxable. If it is not taxable at all, then it is without.
You see, there is another reason for that.
My lord.
Appeal would have been.
My lord.
Your appeal would have been time barred by now.
Yes, sir, it is fair now. The litigation is already there.
So therefore, we say that
No, appeal below the time period. Appeal time period is below, I'll just show me, 120. This order was passed on 28/11/2025.
25. Now we are in May.
26 May. 107.
I think it would be 90 days.
Thereafter extendable also,
Still,
107,
whatever way, but we make it clear that this pendency of the writ petition shall not be a bar for you to file an appeal, if so advised.
Even some judgments are 6 after that also, you can also file simultaneously file also.
That is okay, but
according to me, in my humble submission, following the Gauhati Sarali judgment, when the question of the law, pure law is there,
no, in future, if we direct, then you will be prejudiced. So we.
Yes, there is no liberty, there is no harm in giving the liberty,
Next para. Accordingly, the court is inclined to issue notice, including notice on the prayer for interim relief, returnable on, give a date after 4 weeks.
8 June.
Returnable on so and so. Requisite extra copies of the writ petition with all enclosures be furnished to the learned CGST and the learned learned departmental counsel and the learned government advocate within 2 days. Next para, it is made clear that issues of notice in this writ petition would not preclude the petitioner from filing an appeal against the order in original dated 28/11/2025, if so advised. Next para. As an interim measure until the next returnable date, the Commissionerate of CGST, Dimapur shall not take coercive measures against the petitioner till the next date of listing. Petitioner company till the next date of listing. Next para. The petitioner shall produce a certified copy of this order before the Additional Commissioner, CGST, Dimapur Commissionerate to bring the order to the notice of the said authority. List on so and so.
I'm highly obliged, First time I'm doing the case on the virtual mode before your lordship,
Pardon me?
First time I'm doing the case by virtual mode before your lordship,
Yes.
From the supplementary cost list for motion, item number 28.
May I plead your lordship?
Yes.
Lordship, the instant matter has been filed on 29 April last month, your lordship, and today only this matter has come up for motion. Your lordship, coincidentally, yesterday only I received another so-called notice from the state respondent authorities. Again, as per that so-called notice, I have been directed to show cause why there should not be issue eviction notice against me under Section 5 of the Nagaland Eviction of Persons in Unauthorized Occupation of Public Nagaland Act 1971. So, your lordship, by the time I filed the instant writ petition, this notice was not issued to me. So, your lordship, since again I have not impugned the yesterday's so-called notice in my writ petition, so your lordship, in that view of the matter, I am praying before the honorable court that I may be allowed to withdraw this instant petition with liberty to file a press, because again I have to impugn that the notice which I had received yesterday only, your lordship.
Okay. Mr. P. Suryan, Learned Counsel for the petitioner. And is the court's name? So the appeal for the state respondents. Next paragraph. The learned counsel for the petitioner has submitted that this petition was filed on 5/5/2026 and has been listed.
Lordship, on 29 April last month, your lordship.
No, filing is 5/5.
Okay.
But and is listed for the first time today, Mr. Bhavapama, on 6/5/2026, the petitioner has been served with a show cause notice under section 5 within bracket I, close of the Nagaland Eviction of Persons in Authorized Occupation of Public Land Act, 1971. And accordingly, he submits that in order to assail the said show cause notice, he seeks liberty to withdraw the present writ petition and to approach again. Stop. Next prayer is allowed. The matter is dismissed on withdrawal with liberty as prayed for.
Lordship.
For motion, item number 29.
At this matter. No family possible matter for family. But
For motion, item number 30.
I am aggrieved by annexure A, your object is a judgment passed by borderland colony council, which has no judicial power special in it, but they took up the case and disposed of this.
Where is the order?
Annexure F, page 37, budget. The type copy is also there in the next page.
But this comes within the definition of customary court. It comes within the definition of customary court.
But it is not, the Jubilee we filed an appeal before the Jubilee Commissioner and Review 31. The Jubilee Commissioner dismissed the appeal on the ground that this is the borderland colony, it does not come within the definition of.
Okay, where is that?
Page 75, annexure J1. The relevant portion, paragraph 7 downwards, your worship, page 76. Paragraph 7, if I may read. The expression customary courts is defined under Rule 2A of the said rules as follows. Definition in these rules unless the country.
It's not a customary court.
It's not a customary court, and it is not a statutory body also, the colonial council. It is merely an instrumentality of the state.
You have any information, madam? Whether this is customary court or not? Page 37. Your deputy commissioner says it is not.
Yes.
But according to you, it will be a customary court, it will not be a customary court. It will not come. Okay. But Mr. Chief.
The petitioners can say that the alternative remedy is the motion. You can approach the civil court.
No.
Oh, yes.
This has to go, and then after that, the parties can approach the civil court. Otherwise.
No, if that is without jurisdiction, then section 9 of the CPC will not exclude the jurisdiction of the civil court.
Yes, but so long as this stays.
It doesn't matter if it is unauthorized border.
Yes.
Then,
So it has to be.
No, it has no meaning. She's right.
But our the position is such, the colonies, they enforce their judgments on us. Unless this is question set aside,
No, but how will they do it? They will have to go to police.
they don't go to the police, Your Lordship. They just come and lock the boot lock and key, and then they drive us out, Your Lordship, and the position is such. So since it is an instrumentality of the state, at least. So
No,
at least
no. It will not be an instrumentality of the state.
It is, Your Lordship. It is.
How? Show us
Your
that.
Lordship, I have made specific statement in paragraph 2, Your Lordship. Paragraph 3.
No, to be an instrumentality of the state, there must be either a notification or there would be some order memorandum by authority recognizing this as a.
Your Lordship, the state has set up this colonial councils where they have GPs, conquerors who are appointed by the state, and this judgment has been passed by the GPs along with the other members who were elected by the colony.
So if it is GB, then it becomes a customary court.
No, Your Lordship, the customary court is with regard to only the villages.
Sure.
With regard
I'm
to
very
the
sure.
villages one.
Shows your notification.
This is the notification. I'll take Your Lordship the rules also, the Village Council Act and the rules, Your Lordship. So this is a letter written by the commissioner to the deputy commissioner. So here in paragraph 2, something is written about urban areas. Regarding GPs, this one. Yes. That is with regard to Village Council Act, that starts from page 2, Your Lordship. If these colonies don't come under the Village Council Act. Secondly, the rules, Your Lordship.
Just a moment. Yes, which provision you are showing apart from section?
Your Lordship.
Which provision you are showing?
In the Village Council, this is with regard to the villages one, Village Council Act. They does not have anything to do with the town councils, Your Lordship. And then in the rules for administration of justice and police, Your Lordship, 1937 rules, the definition of village, a customary court is clearly given. That page 1, Your Lordship. Definitions. 1A. The state is made to constitute district customary courts. The deputy commissioner ought to have what said the fact that
No, if that is not a lawful order, he will not have jurisdiction to entertain an appeal. He is rightly done so. Heard Mr. T. Pongan from the counsel for the petitioners. And
Yeah, you.
Government advocate appearing for respondent numbers 1, 2, and 3. Next paragraph. By the case of the petitioners, in brief, is that they are in possession of a plot of land with building at Porter Lane, Porterlane, Porter Lane Colony, Kohima, with an area of covered by land patta book number, 1796, patta/permit number 10468 within bracket capital P, bracket closed, dag/plot number 3060, with an area of 1258 square feet, registered in the name of their mother, late Mrs. Nolehole, Nolehole. Full stop. On the death of her mother, their mother, on 28/2/2020, the petitioners came into possession of the said land. Full stop. It is projected that the respondent number 5, along with help of other relatives, started harassing the petitioners and demanded land and building. Claiming certain rights over the same. Full stop. On 9/3/2026, the respondent number 5 filed a complaint before the Porter Lane Colony Council, where PCCJB case 2026/5 was registered, and by the impugned order dated 9/4/2026, the Porter Lane Colony Council held that the property be equally distributed between the between the deceased mother of the petitioner
and 2 other persons.
Who is this?
These are persons who are not party to the case.
Oh, sure. Dispute between number 1, the mother, deceased mother of the petitioner. Number 2, Mr. Medosa, Medosa, Medosa Rote, Rote. And 3, Mr. Masavito Rote, Mhasivito, Rote, Rote. But they are not parties here.
They were not parties in the case.
No, but once their right has been declared, if you don't assail it, how will we pass orders?
Your Lordship, in the case itself, Your Lordship will see here. Lordship,
no, that we don't know, but some right has accrued to X.
No, in the judgment, Your Lordship. The judgment.
But some right has been declared. He is not a party here. You better implead them, otherwise it will be defective.
But in the judgment itself, the parties are.
That is, you see, I can only suggest. I can't force you. Correct. You better do it. Otherwise, this will not be able to pass any orders. If any benefit arises out of the result of the judgment, giving declaration of right to the property. If he is not a party, then also the Right is accrued.
Your Worship, I was considering that, but because the parties in the
No, no,
main
no,
case, they are
better
not
do it.
parties.
Bring it on record by
Even the
having
mother,
it.
yes, even the mother and they are not
So,
parties. in the
you see
case.
the
Yes.
order against a dead person is nullity.
Yes. So,
The right could not have been given to a person who's already dead. You have not taken the ground of nullity on account of death here as in the writ petition.
you know, I have really taken all those grounds. Yeah.
We don't find it. Where did you say order against a dead person is
They are
nullity?
not parties in the first place.
No, no,
The
this.
mother is not a party. And then
Okay.
paragraph 16, I have clearly mentioned about not making the other parties, and then with regard to the mother.
Where is the
Yes.
complaint?
No complaint, your worship, it was an oral complaint. Oral complaint made.
Where is the order? Where is the order?
Annexure Annexure A. Your Honor.
Page.
37. Page 37. 38 is the type of the front page.
No, it's filed a complaint.
It's
Case background on 9/6 filed a complaint. Oral complaint is not filed.
your worship, they filed it, not me. Mr. Matano Roti, he filed a complaint against.
Filed means, you see, oral statement, can it be said to be filed?
They, according to the judgment, only I'm going according to the judgment only.
I don't know. If you are reading the judgment, I am also reading that judgment. After thorough examination of the deliberations of the statements and documentary evidence.
They produce these documents. They produce these documents on the day. Even we were asked to bring our documents to it. This is how they go about their procedural duties. It's beyond me. We were not even given any copy of it. Even this judgment, your worship, we were given once, told us to read it and then not to keep any photocopy, return it. We somehow took photographs of it, and that is how we are able to produce this document. And after we filed an application before the council form, a formal application form, issuance of a certified copy, I have made specific statement in my petition.
Where is-
How things go.
Where is that?
Your worship, in paragraph. Paragraph 9. Your Honor.
Page?
Page 11. Your Honor. Paragraph 9 of the.
Then you continue with that. You say that
Yes.
Number one, deceased mother of the petitioners. Number two, Medusa Rote, MEDOSA Rote, comma. Number three, Masavito Rote, MHASIVITO Rote. Next paragraph. The learned counsel for the petitioner, by referring to the impugned order dated 9/4/2026, has made three submissions. Full stop. Firstly, it is stated that the three persons to whom the property was to be equally distributed were not parties involved in the complaint. And that out of the three parties, the mother of the petitioner was already dead. Full stop. Secondly, it is submitted that the impugn order dated 9/4/2026 was only shown to the petitioners without allowing them to retain any copies. And full stop. Number three. Thirdly, when the petitioners applied for copy of the order, the chairman of the Porter Lane Colony Council informed that in the event an appeal is filed, he would appear and contest and defend its decision. Next paragraph. It is the further case of the petitioners that they had preferred an appeal before the Deputy Commissioner under Rule 31 of the Rules of Administration of Justice and Police in Nagaland, 1937, to assail the order dated 9/4/2026, but the Deputy Commissioner, Kohima, had held in its order dated 29/4/2026 that the Porter Lane Colony Council lacked jurisdiction and authority to entertain and adjudicate the matter as a court of law, rendering the impugned order void ab initio. Semicolon. The complaint was barred by limitation. Semicolon. The agreement referred to is of doubtful authenticity. Semicolon. The impugned order grants relief to persons who are neither parties to the proceedings nor complainants before the Colony Council. Semicolon. The respondents had no locus standi to. Oh, no, not that. Strike that out completely. It's not the. You just say that the authority by order dated 29/4/2026 held that the Porter Lane Colony Council is not a customary court constituted under Chapter Roman 4, capital A of the rules I have stated up that Nagaland the Administration of Justice and Police in Nagaland, 1937. And accordingly, appellate jurisdiction does not extend to the decision rendered by Porter Lane Colony Council. And accordingly, the appeal was dismissed as not maintainable. Next paragraph. In view of, issue notice returnable on, give a date after 4 weeks, returnable so and so. As the government advocate accepts notice on behalf of the respondent numbers 1, 2, and 3. Requisite extra copies of the writ petition with all enclosures be provided to her within 2 days. Next paragraph, the petitioners shall take steps within 2 days for service of notice on the respondent numbers 4 and 5 by speed post with AD. In the interim until the next determinable date, comma, the impugn order dated 9/4/2026 passed by the Quarterly and Colony Council in adjudication of PCCJB oblique case oblique 2026 oblique 5 shall remain stayed. Actually, just before issue notice, we say that the learned government advocate has raised a preliminary objection to the effect that if the order is without any authority, comma, same can effectively be assailed before the civil court as an alternative remedy is available to the petitioners. Full stop. The said issue raised shall be considered at the time of hearing. You wanted to say something? I heard you saying something, but I was dictating. I stopped there.
For motion, item number 29.
Lordship, I'm sorry, I cannot be here when I'm available.
It's okay.
I was on leg.
No. You don't have to sorry for that. You were doing some work, and that too in court. So this, okay. Yes.
The petitions are before your lordship with very limited prayer, your lordship, just for a direction to the respondent to dispose their claims and objection against the tentative sanitary list which they have by your lordship. Now coming to the facts and break, your lordship, the petitioners, they are serving as the worship's DB, grade 1, your lordship, from the district administration itself. Now by notification dated 8/4/2026, the office will give the commissioner.
Where is that seniority list? Where is that seniority list?
There is a page 27.
27.
Page 27.
And
Now
where is your claims and objection?
page 30, nature 2.
30. Okay, we issue a notice.
Your worship, you see of that, your worship. Now, and may I take your worship to my reading paragraph 4. Paragraph 4, page 9. To dispose of this thing, it will take only 1 day, 2 days, or maximum 3 days, your worship.
Mr.
Page
Jamir.
9, page 9,
Mr. Jamir.
worship,
Uh,
page 9.
You see, that's not the only point. You see, we have had issues before. When we pass orders ex parte, then comes the applications for modification and all, and it multiplies our work. So since I'll be disposing of I'll be issuing notice, I can dispose it of on the next date. And in the meantime, if the orders are passed, it becomes infructuous.
Then interim protection and not to act on the same tentatives and legal list.
Obviously, they can't.
Loss.
Okay. But Mr. TV Zamir, counsel for the petitioners who are presently serving as grade 1 DB under the Deputy Commissioner KIPHIRE, KIPHIRE. Full stop. By notification dated 8/4/2026, comma, a tentative seniority list was prepared and claims and objections were invited against the said tentative seniority list. Full stop. The learned counsel for the petitioners has submitted that pursuant to the said notification, comma, the petitioners had submitted their claims and objections, comma, claiming to be placed for them to be placed senior to the others, as more fully mentioned in the said representation filed on 9/4/2024, right?
Yes, 9/4/2026 and
26. Oh, okay.
page 41.
No, page 38, I read this as 24, down signature.
Page 38, you had a copy, I've given a page.
No, but that signature, you see the date
Yes.
down below, it appears to be 9/4/24.
When should have been there, I think they have made it, should have been, I think they have done it.
I don't know. Okay,
Because this
26,
is-
9/4/26.
And the second question
And?
by the petitioner is at page 44. 18,996, page.
And 18,990,
18,4, bottom.
18/4/26. Full stop. Next paragraph. Accordingly, the limited prayer of the learned counsel for the petitioner is that the Deputy Commissioner KIPHIRE, who is the authority to dispose of claims on objections in terms of the notification dated 8/4/2026, be directed to dispose of the claims and objections at an early date.
Before taking any action based on the tentative results.
Before taking any action pursuant to the tentative seniority list. Next paragraph. Issue notice returnable on 3 weeks. Returnable in 3 weeks. First of requisite extra copies of the petition with all enclosures will be furnished to the learned government advocate within 2 days. Next paragraph. The learned counsel for the petitioners has submitted that the petitioners apprehend that the tentative seniority list would be given effect to without disposing of the claims and objections. So in that view of the matter, as an interim measure, court is inclined to observe that, inclined to provide that the respondent authorities, without disposing of the claims and objections, shall not take any, do not give effect to the tentative seniority list. Till the next date of listing. Next list also and so. You have fixed date after 3 weeks.
I love that.
So this will go in the last case that Ponganer matter.
For admission, item number 11.
Yes.
Here, the case of the petitioner is under office now, please. in case of the petition.
Is under process,
Yes, sir.
but. Stop. We take it up after 3 weeks again?
Just not even dispose of question.
No, but the problem is that if we, on that assurance we close it, is in process would mean how many years we don't know. She may be aggrieved by that. Huh? You shows the development, we adjourn it so that she is protected in the meanwhile. It becomes very difficult for some people to come to court again. Okay. Both sides are represented. The government advocate submits that as per instructions received by her, the case of the petitioner is being considered. Full stop. Next pair accordingly. Court is inclined to adjourn the matter today. List after how much time?
3 weeks, sir.
3 weeks.
Not only here.
For admission, item number 19.
Mr. Lordship, can you allow me to withdraw this petition, Lordship? Lordship, petitioner here is seeking to bear purpose under the category C of person with disability, and the state respondent has filed their affidavit stating that our case is under consideration. So, Lordship may kindly record a statement of the state respondent at paragraph 7, page number 4 of their affidavit in the order, Lordship. On seeing this, the petitioners would not want to press the petition further, Lordship.
Okay. Miss.
Kelly Lisu.
K. Lily Su SWU. K. First of Lily LILY SWU. Learned counsel for the petitioner. You just say first heard counsel for the petitioner as well as Ms. V. Sukri, learned additional advocate general for the state. Next para. Upon instructions, the learned counsel for the petitioner has referred to statement made in paragraph 7 of the affidavit in opposition filed by respondent numbers 1, 2, and 3 on 19/3/2026, wherein it has been stated that the representation dated 6/10/2025 submitted by the petitioner has been recorded and her name is under consideration for appointment to grade 4 post in the next recruitment process for MTS.
Any grade 4.
Any grade 4 post. Okay, any grade 4 post. Stop. Accordingly, she submits that in view of the said statement, the petitioner does not want to press this writ petition with liberty to approach again if so advised. Next part. Trade is allowed. The matter stands.
The office beyond. Because she is attending under PWD, person with disability. So her application is only for office beyond, so it should be for office beyond.
No, if it is PWD and it is grade 4,
Yes.
then if she cannot be fitted in
No,
peon.
We have big short everything in Russia because she's the dolphin, so she can't do the other jobs.
Okay. Appointment grade 4 post. Appointment to the to grade 4 post of office beyond.
Yes.
Next, the matter stands dismissed on withdrawal with liberty as grade 4.
For admission, item number 20. May I please, your lordship? May I please, your lordship? Lordship, I'm very for the petitioners in this matter, lordship. This matter has already been admitted, lordship, last order dated 2/4/2026, lordship.
Yes.
So this matter may kindly be come up for hearing on 12th of this month, lordship.
But I'm here. I'm for state responsible, the 5, 6, and 7. I'm yet to receive the extra copies of the release.
We will serve the extra copies, lordship.
Huh?
I'm yet to receive extra copies for service of the notice on the state responsible, number 5, 6, and 7.
Oh, so you have also not filed your response.
I'm yet to receive extra copy.
So that means you have also not filed your response.
Lordship, in this matter, rule has been issued, lordship.
But copies you'll have to give.
Yes, lordship.
We'll recall the rule. You see, we have issued the rule. We'll recall the rule.
We will serve the extra copies before the next date, lordship.
Since I'm yet to receive extra copies.
Both sides are represented. Mr. L.D. Sankram, learned additional AG, appearing for respondent numbers 5, 6, and 7, has submitted that he is yet to receive extra copies of the writ petition in terms of order dated 2/4/2026. 2/4. First of the learned counsel for the petitioner undertakes to serve extra copies of the writ petition to the learned additional AG within how much days? How many days? You serve copies in how many days?
Within 1 week time, lordship. Within 1 week time, lordship.
1 week time.
Within 7 days, lordship.
Okay, within a week from today.
Lordship.
Accordingly, as the state has not been accordingly, the state is granted 6 weeks time to file their affidavit in opposition.
Lordship, I'm praying for listing on 12th of May.
No point, sir. You'll serve notice after copies, extra copies after 1 week from today.
I will serve it tomorrow itself, lordship. I will serve it tomorrow itself, lordship.
You see, we take cognizance of whatever you say. But that will depend on us. We'll extend 1 more week now. You must suffer for that non-supply of copy. The amount of submissions you continue to make will extend the time for 1 week on each submission. The state, writ petition is voluminous. He will have to take instructions.
Lordship.
No. Rule does not mean that without service of copies, without affidavit, the matter will be heard. 6 weeks time from the service of extra copies of the writ petition. Next para. List in the awaiting the filing of affidavit in opposition by the state respondents. List after 7 weeks date. List on so and so.
Lordship, can I pray for a date, lordship, since we are outstation councils, lordship?
We'll give a date.
Can it be on 13, lordship?
No, we give 7 weeks, 6 weeks to file their reply affidavit and 1 week for you to give the copies. It will not be before 7 days.
On 20th, lordship, 20th of June. That will be after 7 weeks, lordship.
He'll give a date. The court master will let him calculate.
26 of June.
26/2026.
Lordship, much obliged.
We'll take a break and come back.
और दो तीन सर तो वो मैट्रिक्स मीनिंग और ये मोशन ना ये रे और स्टेज ओके
22 हो गया अपना 26/6
26/6.
okay next 19 disposed withdrawn 11 to after 3 weeks
After 3 weeks.
সেনেকে থৈ দিম okay and এইটো আছে কিমান 29 টো আছে আপোনাৰ 28 29 to 28
What's my cost list?
29
Oh, 29, no? Oh, 28.
25 और इसके बाद है पहला वाला जो 30
from 4, 6.
for 6 okay okay for 6
Yeah, legal.
yeah yeah we maybe like us
submit the petition will be allowed to have the affidavit as soon as the original copy of submissions paper is received.
So you have to file that affidavit. Okay. You are Miss M. Vo, Learned Counsel, heard Miss M. Vo, WEO, Learned Counsel for the petitioner, was submitted that the notice on respondent number 2 was published in a local daily having circulation in the state of having high circulation in the state of Gujarat. First off, it is submitted that the newspaper publication was made on 3/5. Correct? Yes, 3/5/2026, and she is awaiting receipt of the newspaper for filing of the affidavit of service. First off. Accordingly, matter stands adjourned today. List after matter is to be listed after how much time? Weeks.
Yes.
I'll give you a tip. I'll give you a tip. As a lawyer, you'll have to do multitasking. You know what is multitasking is? One eye towards the judge, one ear towards the judge, and lip reading. Correct? And so far as I am concerned, if you don't understand what I am trying to say, you will ask me, not the courtmaster. Correct?
For admission, item number 31.
Yes.
This petition and this petition, I'm praying for the direction also, the payment of rent, as well as premium equivalent to the cost of compensation in terms of the notification issued by the state government from time to time. There's also the guidelines issued by the ministry, which are also included in the petition. Also, the three facts of the case is the Assam Rifles, they have occupied my land, measuring an area of 6.61 acres in the year 1986.
Land measuring
6.61 acres of land.
yes.
It was in the year 1986. So, the details of the land occupied is in paragraph number 6, page number 7 of my reading stock. Also, you're not going to see the questions.
Just a moment. Mr. Gauhati, this in your affidavit, you have made a statement at paragraph 11. Sorry, page 11. Please come to that, page 11.
Oh, I have it.
Of your affidavit, page 11. Yes, now you have said here that the petitioner has received land compensation twice,
Twice.
55 to 76 and 81 to 83. That is not by you.
This should, they have given the municipal authority.
You see, Assam Rifles did not have the land in 83. You took in 86. So 83, what land is being paid, that is not his claim also.
Yes.
From 86 onwards, you are in occupation. Have you
Yes.
paid any rent?
No.
Then you admit your liability that you have to pay rent.
We have, between the state government and again, to service land, and as per the procedure to hand over then it was. But we have not, no action has been developed, so we can.
Then you vacate the land. If you have not been given land,
Yes,
you can't occupy it.
yes.
You vacate the land. How many days you will vacate?
No, it's not a question of verification, Lordship. I have already listened to the state government.
No. You are taking a stand
Yes,
that number one, you are not handed over the land.
yes, we have.
If you are not handed over the land, you will be in illegal occupation. Can the armed forces come and say that we will illegally occupy your land?
That is why, Lordship, we have written to, since after regulatory survey, we have written to the state government to survey the land and they will let us purchase it. But the survey is not been done.
Why they will do it? You took the land from whom? State? Who gave you the land? You say that no. You say that CRPF gave it to you. So if CRPF gave you, CRPF is government of India?
Yes.
You ask your government of India to give you the land? Why you are asking the state government to give the land? State government is not the owner of the land.
Because
Please tell us who is the owner of the land.
if my lordship may come to page 8 of the.
I have read it. That's why I am asking you only one question.
Yes.
I have not asked you many questions. I have only asked one question. That according to you, who is the owner of the land?
The landowners.
Landowner is
Yes.
and in Nagaland, who is the owner of the land?
It is landowners.
Land ownership is with the citizen, not with the state.
No.
Then why will the state give you possession?
Because if my lords will come to, when they come to you on page 8 of the
8 of
next chapter.
page. Give me the page.
This is the order of notification of the land revenue.
Page.
The relevant portion is page 30, yes, of the affidavit.
30
Yes, of the petition.
of the petition, rate petition.
Of the petition. The notification and the is type of the very good.
Yes.
This is the government of Nagaland Land Revenue Department, so in consideration of the development or also so there is a The government of Nagaland is pleased to state that land acquired by the land is pleased to state that land acquired by the single government or private agencies for the purpose considered to be in public interest shall be leased out to the state agency. So only after the state government we take over the land and they can lease out the land to the single agencies. So the central government we have direct authority to take over land.
This will relate only to government land. Please read this notification complete. Read it complete. It doesn't say private land will be leased by the deputy commissioner. Will the deputy commissioner have authority to execute a lease for a private land?
Yes.
He has
Duly the government the power
to make lease for his land.
yes, make lease on.
Under which law? Under which law?
And this is a legitimate.
You are misreading this notification. That's why we said read the complete notification.
Beginning question.
Yes, yes.
In cancellation of this department OMs, for example, the 680, the governor of Nagaland is pleased to state that land required by central government agencies or private agencies for purpose considered to be in public.
So therefore,
interest
central government agencies and number two, private agencies. Correct? Required by private agencies. Now continue reading.
shall be leased out to these agencies, payment of a premium equivalent to the cost of compensation paid by the landowners.
Paid to the landowners.
Paid to the landowners, yes,
Huh.
for acquisition of the land and on payment of annual rent.
As may be prescribed.
Right.
So therefore, the rent is to be paid to him, not to the central government, not to the central government or not to the state government.
Then it's to be given to him but through the state government, not that.
That's why I showed you. You see, with all this, you come to the same paragraph, page 11. Rent was paid prior to 1983.
Yes.
Did you pay it?
Perhaps not.
No. Then you vacate the land. As simple as that. You don't want to pay. You ask the state government to tell you what to do.
Because that's where this ownership the land has to be acquired by the state government. The first, only after the state government we acquire the land.
Acquisition doesn't come here anywhere.
But I cannot just go and occupy a original land ownership.
Therefore, you admit it is illegal occupation.
I'm not saying it's illegal because this land was handed over to me by some CRPF motion.
How would CRPF give it to you?
That is
Very simple. I'm asking a very simple question. You have a house. You rent it out to your friend here next to you. Correct? He stays there for 1 month. He vacates and he rents out to his friend there. Is it permissible? Will you allow to do in your house? Will you allow to do that? The tenant to sublease it to someone else?
the argument we are.
I'm asking
we have not said we will not pay.
Then pay it. Either you pay. You give us an undertaking by when you will pay.
But we.
But if not, you give an undertaking by what time you vacate.
No, the question of vacation is not that we want to occupy the land. We have refused to state government to acquire the land.
State government will not do it.
State government,
It will not do it. And it can't. Constitutionally, it cannot. 371A protection is there. You think the private land, the government will take over and give it to you?
If this is CRS, this is CRS.
Is there a notification? Is there a section for notification ever issued requiring the land? No. Is the preliminary assessment made with regard to the requirement of land under the Land Acquisition Act then 1984? No, 1894, no. Has it been done under the new Act, 2013 Act? Answer is no. Then how you want state government to do anything?
Because we cannot just go track the land ownership. That is what we are in the state government.
You have already occupied land. You have done more than land grabbing. You tell us within what time you will make the payment.
As long as the rent is.
We will pass in the order that the state government is not even authorized to touch that land unless they acquire it. They will not decide to give you the land. Ownership of land under 371A is with the private person. He will decide whether he wants to give it or not. You have an arrangement with them, they are consenting to it, they are wanting rent. They have come here only for rent. Now, how does the state government come in?
Because it's, as per this notification, the first has to first acquire the land. And it is be given to civil agencies.
Therefore, till they do it, you vacate. Till they do it, you are an illegal occupier, you please vacate. You can't take law in your own hands.
We have not said that we would not pay. We have said that we will pay as long as the process is duly taken care of. That's why we have written.
There's a small story.
We have also written.
There's a very small story. Am I permitted to say that? My examples are always horrible. You consider that. You see, a man goes to a cobbler and gives him his sandal or shoes for repair. The cobbler does the repair and asks for 20 rupees. That I have repaired your shoes, please give me 20 rupees. The man goes and tells the cobbler, well, okay, I'm writing your name in the due list. I have not even paid to the shop owner for the shoes. So when your turn comes, I'll give that payment. Is that your case? That I have written your name in the due list, having exhausted all other payments, then I'll give it to you. Is that you want to say?
How we pay and who will receive it is also the ownership.
Who will receive?
Yes, of course, ultimately the landowner who will receive.
You don't know who is the landowner?
We know now, we know that with the certificate that is issued, we know that the landowner is just not people.
So you need DNA test?
No.
Then
How the justify will proceed because Iraqi cases knowing and all of that.
we are not knowing that. You show me a procedure under any notification of the state government, any law in the state government, that for private land abrogating Article 371A, it will be the state government who will do the agreements, who will get the money, and then the state government will make payment to him. Show me any authority.
There is no authority because in other cases also, it might not be
you are exercising. You are exercising power which is not vested with you. You are occupying it illegally then nothing else but illegal occupation. You come to this your affidavit. Please tell me where is the document of handing over and taking over from the estate from the CRP? It's not there. So how do you justify that you have taken over?
So for all this, I was thinking that it's not good.
That's why. And that, you see, a transfer of a land by under any laws applicable in the state, a transfer of land by a leaseholder to another sublease is illegal. Not only the laws in Nagaland, any laws in the country, that is not permissible. When you took over, did you take the consent of the state? That document is also not here. That we want to occupy the land of X from CRPF by the Assam Rifles. Is that document here? No.
No, independently.
So when you take over the land, you don't need the state permission. But when you want to have to pay the rent, then you want the state's permission. State will do this, state will do that. Then you will pay. I mean, what is the difference between you, Assam Rifles, and an unscrupulous borrower who doesn't want to pay to the bank after taking loan? What is the difference between you two? Your actions are totally unscrupulous, if you may say so.
There is no misgroup that they are taking over the land from the CRPF. I don't know how this processing was organized, but the purpose of it.
We record this and put it to notice. On the next date, you respond to this, or otherwise will observe that you are required to make payment. The state will not do anything for you to do survey, resurvey, anything. Now, please tell me, if you rent out your house to X, and for one day, there's no water. Water is not supplied by, created by you. It comes to the municipal corporation. They give supply, water supply. For one day, the tenant does not get a water. Will it be permissible for him to deduct rent because of non-availability of water? No. You take over a land and then say that NIZ DCL took away some land for road development. Correct. Now the road which has gone out of the hand of your estate is known to you, or you are saying that your estate officer does not know how much land he has, what land has been taken away by the NHI DCL for broadening of the highway. Your estate officer does not know anything. Is that your case?
No, we have always said that some land, portion of the land.
I understand, but what does your estate officer do? He has only one work, to look after the estate land. Now, out of say 100 meters of land, 5 meters have been taken away. Is it your case that your officer, who is the land estate officer, does not know anything, does not know, has never done anything to measure the land and to know the land available in the estate? It's not your case. So you know that how much land has been reduced. And you still need a resurvey. You have built a house, correct? The architect gave you a drawing. It says your super built area is 100 square feet, carpet area is 90 square feet. Please tell honestly, have you ever gone into your home and measured and found out whether it is 90 square feet carpet area available to you? Have you measured it? No, nobody does. So if the principle of caveat emptor applies, when you take over a land, you take that land with knowledge of what is there, caveat emptor. You know the land, you don't take documents, and then when it comes to rent payment, then you say very easily say that no, state will do this and then we'll pay. 86, and now we are how many years? 26, 40 years. So if next 40 years the state government does not wake up, what you will do? Not pay him.
That's why we're in the statement. Research. So
State government will not do anything. It does not have power and authority to do so. You show me the law that the state government will do it. You see, you will say a proposition which is unacceptable in law, and then you say the state government will comply to it. I have a very horrible example. Can I say that also? You check your mobile, you will find that in Rajasthan, a very terminally ill boy, I think 11 years or 7 years, he was terminally ill and he made a request to the state government to make him the deputy commissioner or a police commissioner for a day. I forgot. I read it long back. 20 years back, I had read it. You will find that he's either the deputy commissioner or the police commissioner. He made the request. You check your mobile, please check up. Boy, terminally ill boy made commissioner for a day. And the state government considered to that request, he was made the police commissioner or the deputy commissioner for a day. Correct? Supposing today I make a request to the authorities that please make me the Army General for the country, CDC, will they do it? No, they will not do it. So therefore, you see, if I make a demand that for a boy you can do it, why you don't make me the CDC? You are in Article 14, equally I am not treated. It's not a tenable argument. With this horrible example, I am trying to tell you that if you, for a private land, if you insist that the state government will do something, we are living in a artificial world. Please tell us, you know the law, you know Article 371A. Please tell me whether the state government can interfere with the private land and do what you are wanting to do. No? Then you put down in the order and you take a call. If the authorities do not accept it, you pass an order. This is unfair. You can't take over the land and not pay for next, you don't know how many years. We'll record it. We give him time, 10 days time to take instructions. Heard Mr. M. Jamid, learned counsel for the petitioner. Also heard Mr. Yangarwati, learned CGC for the respondents. Next para. From the stand, next para. The prayer in this writ petition is for a direction upon the respondent authorities to acquire the land occupied by the Assam Rifles by way of executing fresh lease on payment of premium equivalent to cost of compensation. Stop. As per the stand taken in the affidavit in opposition by the by the respondent numbers 1 to 4 is to the effect that they had taken over possession of the land in question from Central Reserve Police Force, who were holding 6.61 acre of land since 1956. Full stop. By 23rd Battalion CRPF, 23rd, 23 BN, small capital B, small n, Battalion CRPF. And since 1986, the said land is in occupation of the Assam Rifles. Full stop. It is further projected that the Assam Rifles had intimated the authorities for a resurvey and assessment of the rates of land for compensation and for payment of rent under the Land Acquisition Act, 1894. Stop. It is further stated that as way back in the year 2015, the authorities in the Assam Rifles had moved the Deputy Commissioner in 2015. Yes, you moved the Deputy Commissioner when?
Mm.
2013 for resurvey of the land for the purpose of acquisition and payment of rent. It is also posited that in the meantime, for the widening of road, some part of the land under the occupation of Assam Rifles has been taken over by the state Full stop. From the said affidavit in opposition, it appears that since 1983, no rent or compensation was paid either by the CRPF or by the Assam Rifles after 1986 to the petitioners. Full stop. In the affidavit in opposition, no document has been produced to show as to how the handing over and taking over of the land took place between the 23 Battalion CRPF and the Assam Rifles. Full stop. It is generally known that the army establishment has an state officer who is supposed to be aware of the land holding of the state under the control of the armed forces. Full stop. It is not the case of the respondent numbers 1 to 4 that their state officer is not aware of the land holding or the land which has been taken over for expansion of the national highway. Full stop. Thus, it appears that for last 40 years, since 1986, just because the state government did not make the survey, the Assam Rifles has neither made any agreement with the landowner nor has paid any rent or compensation, even on ad hoc basis till the rent is finalized. Full stop. From the inaction on part of the state respondents, it would also appear that if for next 100 years, the state authorities don't make the survey or resurvey, the Assam Rifles would be occupying the land without any payment of rent. Full stop. This appears to be completely unjust and unfair on part of the state machinery, including the Assam Rifles, to be holding over a plot of land of the petitioners without making any endeavor to make any ad hoc payment of rent. Next paragraph. The learned CGSC has referred to to a copy of the notification number capital LR /16-37/72 dated 8/6/1987 to project that under the said notification, agreements are required to be executed between the acquiring authority, the central government agencies and the deputy commissioner in respect of the land held by such central government agencies. Full stop. In this regard, it appears that in view of the constitutional protection under Article 371, capital A of the Constitution of India, the ownership rights over a plot of land which is held by a private person in the state of Nagaland vests with the citizen. oblique people of the state of Nagaland, and state is not the owner of the land. Full stop. Under such circumstances, it is the respondent numbers 1 to 4 has not been able to show as to by application of which law agreement for a lease out of a private land can be entered by the state government without first acquiring the land. Next paragraph. As there's nothing on record to show that the respondents took over the land of the petitioner with the consent of the landowner, it emerges that it is made to appear that the possession of the land in question by the Assam Rifles was without any authority of law. Full stop. Next paragraph. It also appears that the state government, due to its inaction to do what is required for land acquisition, is sleeping over the request of the petitioner and the Assam Rifles authorities to do the needful so that an agreement can be made between the Assam Rifles and the owners of the land so as to have the rent, to have compensation in form of rent. Next paragraph. Therefore, the court is inclined to put the respondent numbers 1 to 4 and to the which are the instrumentalities of the Union of India, and respondent numbers 5 to 7, the instrumentalities of the state government, to respond to the court query, following court queries. Number 1, why the land occupied by the Assam Rifles in this case and in connection with the present petitioners should not be declared as illegal and void ab initio, because without any authority of law from the state government, they took over the private land. Next, number 2. As the possession of 6.61 acre of land is not denied, why the state government should not be directed to pay land compensation in form of rent to the petitioner within a time frame to be fixed by the court, and recover such rent from the acquiring authority, that is the Assam Rifles. Number 3, why in the absence of any action on part of the state respondents and the respondents in the Union of India, the court should not fix the rent for the land, taking into account the present market value.
Is it the grounds and ground
Where? They have not given the rate. Page 30. They have not given the rate. 36.
Verse 6 of the reviews. The type copy is a decision, okay? The actual.
Is the rent taking into account the notification dated 15, notification number LR/2-6/93 within bracket part PT bracket close dated 15/9/1995, comma, taking into account the present market value of the land. Next para. Both the Union respondents and the Union of India respondents and the state respondents are put to notice that why exemplary cost and direction to pay interest should not be passed by the court to compensate the petitioners for loss they have incurred, financial loss they have incurred for non-payment, non-receipt of the rent for last 40 years. Next. Why in the absence of payment of rent, the court should not issue a direction for the Assam Rifles to exit from the land within a time frame to be fixed by the court. Next para. The court is conscious of the fact that these are not the nature of prayers made in the writ petition. First of all, however, in order to do complete justice to the petitioners, the court would have, in the opinion of the court would have power to mold reliefs. Next para. Accordingly, these we have put the union respondents and the government respondents to notice of this order, at least after 2 weeks. Who is for the state government? You are appearing. This team formed the additional advocate general. 5, 6, and 7 is represented about it. Next, we request the learned CGSC and the learned additional advocate general to transmit a copy of the order to all the concerned respondents.
Okay, we'll produce last. Okay, maybe produce last.
You'll get it. Downloaded copy now is available.
This version.
If you still don't want it, he'll give it to you, the court master. Just tell him. But download copies are available.
Yes.
That's why we have said downloaded copies.
They will give one the same.
Huh?
Obviously, one the same copy that is right.
No, in the order we have said downloaded copies. If they insist, please give us their name and address, their rank. No, I'm very serious about it. For a moment, I'm not taking it lightly. If the authorities doubt the downloaded copies, even in the order when I have ordered that, you please provide us the rank and the name of the officer. We'll directly provide them. We'll take interest in sending a person from here and then giving it to the said authority. We can assure you that. We'll do that personal service. What you call? Zomato service. Or Blinkit. We'll do it.
For admission, item number 32.
Okay. Oh, shall we attend? Okay. We just adjourned it. We don't say anything here. In one case, we have already passed orders. We say both sides are represented, all sides are represented, list after 2 weeks.
You file more matter in name.
Ready? Yes.
But this IS file for extension of period. By order dated 21/2026, this honorable court has directed the respondent.
Regularization.
Lord from the man is in the cover of page.
You have seen that regularization was ordered.
Yeah.
Yes.
So, my lord, the case of the petition is under processing under consideration, and it is before the then personalization committee, my lord. So
Where is that?
I have mentioned in paragraph
Para 2.
Yes, my lord.
You need how much time?
There is 6 months, my lord.
6 months.
Yes, my lord. Because from emergency, it will go to cabinet.
But 6 months, you see, you are asking for 6 months.
Yes, my lord.
This order was passed in January.
Yes, my lord.
5 months has already gone by. 4 months. So that means 2 months more.
Yes, but from the date of expiry, my lord, that is 23, 2026. That's
From that day to 6 months more.
Yes, my lord.
Yes.
Yes, my lord.
But what, as far as the department is considering my case, I have no objection.
Okay. Heard Mr. E. T. performed an additional advocate general for the state.
My lord, government, senior government.
Senior government advocate. I'm growing old. I'm making mistakes. Appearing for the applicants. Also heard Mr.
Justin Mark.
Please write it down. Otherwise, we'll make mistakes. Learned counsel for the respondent, who represents the petitioner in this, who represents the petitioner. That was disposed of by order dated 22/01/2026. Passed in WPC 187 of 2023. Next paragraph. The learned senior government advocate has submitted that the application of the petitioner, that pursuant to the orders of this court, the case of the petitioner is been examined for regularization and the same is under process. First off, it is submitted that the process involves clearance from the Personnel and Administrative Reforms Department, thereafter finance clearance is required, and thereafter manpower rationalization committee clearance is required, and thereafter the matter is placed before the cabinet for approval. First off, it is submitted that this court, by the order referred above, directed that the process be completed within 3 months from the date of the judgment. First off, it is submitted that the entire process may take about 6 months time from the time when the implementation of the order was to be made. Full stop. The learned counsel for the respondent has submitted that till such time that the respondent authorities are considering the application of the petitioner, he would not object to the prayer for extension of time. Next paragraph. In view of the projection that the case of the petitioner is being looked into and considered for regularization, with effect from 1st of April 2026, 6 months time till the expiry of 30 September 2026 is granted in terms of the prayer made. Full stop. Next para, we hope and trust that within the extended time, the needful shall be done. Next para. This introductory application stands disposed of.
Next, much of it.
So, this IA will go to the record of the rate petition. It will be attached there, na?
Yes, Lord.
Huh? We don't have to pass any order or attachment. No. To give this record there, no. We don't, order is not required.
For orders, item number 1.
Yes.
My lord, I'm challenging the implementation order dated 17/11/2025 with an annexure 3 on base 45. On the main tree ground that, well, at the time of passing the existing order, the cleaning authority have not given a genuine apprehension that the detainee would be released on bail. As after his arrest on 26/6/2025, and at the time of passing the existing order, which on 17 November, the detainee has not moved a bail application at all. This fact was not taken into account. As such, the detention order is illegal. It's illegal, my lord. And in the instant case, his co-accused was already released on bail. But the co-accused, he was not detained. Only the detainee was detained under the PSA. The co-accused, he was not detained under the same act. And my lord, the other ground is that during the serving of the ground of detention, the detaining authority have failed specifically to mention that the representation had to be served at the earliest, and he have a right to be assisted by a friend. And the detainee is illiterate, and he cannot present himself properly before the advisory board during the time of hearing, since he is illiterate. But for an enlightened person, the assistance of a friend is not necessary. But since he is illiterate, he has a right to be informed that he has a right to have assistance of a friend, and the representation had to be made at the earliest. But at the ground of detention, which is annexed in Annexure 4 on page 46, the detaining authority has failed to mention. My lord. And on the ground of detention, page 5, it is mentioned that you are presently under judicial custody on the basis of material placed before me. I have decided you are likely to indulge in similar judicial activities unless you are prevented from doing so by an appropriate order of preventive detention. On paragraph 6, if not detained, you are likely to be released on bail, and you will continue to be a threat of the peace and security of the state of Nagaland, no regional and other states in the country. The reflection of people continuing in the illicit trafficking of ONPS and may not cooperate or hamper investigation, and moreover influence drug traffickers, syndicates, thereby obstructing investigation. And my lord, I want to bring to the attention of this woman for is that after his arrest, he has stayed in custody for almost 5 months. 5 months. Only at that time, the detention order was passed. So from the date of arrest to the date of passing of the detention order, he has not moved a single bail application at all. So there is no real possibility of him being released on bail, since he has not moved bail application at all. And that he may not operate or hyper investigation. There is no such job because he's under custody, and he has no other option but to cooperate with the investigation. And there is no chance of him to influence witnesses. And my lord, I rely on three cases. First is 2011 5 SSC 44.
in Red versus State of Tamil Nadu. It is clearly observed by the Honorable Appeals Court on para 7. On para 7 if I may be allowed to. A perusal of the above statement in para 4 of the ground of detention shows that no details have been given about the alleged similar cases in which bail was already granted by the concerned court concerned. Neither the date of the arrest bail order has been mentioned here, nor the bail application in the same case, nor whether bail orders were passed in respect of other co-accused in case on the same footing as the case of the accused. All that has been said in the ground of detention is that in similar cases bail were granted by the courts. In our opinion, in the sense of details of this statement is mere exists and cannot be relied upon. Now, when this itself is sufficient to vacate the detention order. One more on para 30. On para 10 and 11 also, it is clearly stated that in our opinion, details are given by the responsible authority about the alleged bail order in similar case mentioning the date of the orders, the bail application number, whether the bail order was passed in respect of the co-accused in the same case, whether the case of the co-accused was on the same footing as the case of the petitioner, then of course it could be argued that there is likelihood of the accused being released on bail because it is normal practice of most courts that if a co-accused has been granted bail and his case is on the same footing as that of the petitioner, then the petitioner is ordinarily granted bail. However, the respondent authority to have given details of about the alleged bail order in similar case, which has not been done in present case, a mere official statement in the ground cannot sustain a different order and should be ignored. In our opinion, the different order in question only contained legitimacy regarding the alleged imminent possibility of the accused coming out on bail, and there was no reliable material to this effect. Hence, the detention order in question cannot be sustained. Paragraph 12. Moreover, even if a bail application of the petitioner relating to the same case was pending in a criminal case, the detention order can still be challenged on grounds from other court that the aid in question related to going order and not about the order. Your third material on notice that the order was passed, you were verified that the order wasn't passed by the police party and the information specific claims were exercised with the following action. That the subject of discussion was irrational, that your application was mine, that the grounds are fact, definite, relevant, external, or recent or state. That there was a delay in passing the order or delay in executing it or delay in deciding the application of the agreement, that the order was not approved by the government, that it was failure to refer the court, or that has been was dated as a strong. Paragraph 13. In our opinion, Article 2.3 of the Constitution was established for me to predict the effective to Article 21 of the Constitution. The application exception is an exception and cannot ordinarily notify the school for the name. It is a right to liberty of Article 21 of the Constitution. Fundamental right for protecting the civil liberties of the people and not to put them in jail for a long period without recourse to the lower and crime. As observed in our view, so the imposition of what is effective of prison by the side of the jurisdiction of trial right and the return of the rule of law. As to Article 1 is the most important of the fundamental rights guaranteed by the Constitution of India, because it is the most important rights won by the forefathers after long history of others. Our forefathers relied freely because they had seen during their freedom travel, civil liberties of our countrymen credible upon by foreigners. This is why we determined that the right to individual liberty be based on a high spiritual along the right to life as basic right of freedom in India. Lord,
In this, in your petition, you have not pleaded that the co-accused has been granted bail. In your petition, you have not said that. You made a submission.
I'm just because the co-accused.
I'm asking whether you have pleaded or not. You made a submission.
But initially, he was under medical grounds for interdiction. The co-accused.
No, if you have not pleaded, you please don't tell us because that will only be a story. I am good storyteller.
No, what I'm trying to point out is that there are two accused.
Please confine your submission only to the.
So here's my comparator. Whenever I order other criminal detention, so challenge one of the questions about my activity is what's the ordinary law to let the situation If the answer is in the affirmative, it is not ruled illegal. In the present case, the first second is also selling expert drugs and selling the labels. Showing the reason for using the chemical the drug because of the was related to the situation. Hence, in our opinion, there is a police reason also in order in which was illegal. Here, the discipline is first under the NGPS Act, and there is special laws to deal with the offense. And on paragraph 36, it has been held that the history of liberty is the history of procedural safeguards. See Communist work is for that controversial in India by paragraph 9, disposal safeguard are required to be seriously was enforced by the court and the legal penal they allowed to be delegated in the basis of nature of the legal case to be referred in the water sea process contact. We evited the smuggler who strike and the number of the instructions specifically in cases of life Indian community, but the laws of paying citizens for more than of safeguard persecuted under them and freedom and liberty are any meaning not legally set up. This is what it was safeguard are not denied to the
Here you have not made a statement that you are exempted from having an inner line permit. You are a resident of Manipur. Were you carrying an inner line permit when you are traveling through state of Nagaland? Or you are not required, you are exempted?
No, it's not required. Right.
It's not required. Okay. Yes, correct? Not required. Okay.
In the next ruling, withdrawal Colombo State versus Manipur and others, 2012, 7 SEC 181, paragraph 9. In view of the above, can be held that there is no prohibition in law to pass a different order in respect of person who is already in custody in respect of a criminal case. However, if the decision order is silent, the beginning authority has certified the court of aforesaid. The authority was fully aware of the fact that the detainee was peacefully in custody. There was relevant material before the authority on the basis of this. It was reason to believe that there was a real possibility of his release on bail and whether further on being released he would probably indulge on activities with the previously public order. In view of the above, the authority felt to prevent him from indulging such activity and therefore the decision order was necessary. In case either of these facts do not exist, the decision order will stand dictated. The present case requires to examine the light of the aforesaid better legal proposition. My lord, in this instant case, similarly, the detainee, there was no material or any chance of him being released on bail. That fact was not taken into account by the detaining authority, and they have failed to mention in the decision order. Since there is no real possibility, the detaining order has not mentioned because the detainee never moved bail application. So there is no chance of him being released on bail. In this round, the decision order is just is to be passed. Then on paragraph 12, which is in recover terminal 2, which have already said that the court was dealing with the issues held on paragraph 7, the issue of the above statement in paragraph 4 of the ground of the so because I think given about that.
You already read, Rekha. Why are you repeating it?
Yes, my lord. And on the last order judgment, I rely on 2007 for GLT 200 in case of numeric found in a two passing process in India. Paragraph 14.
Yes.
The argument advanced by the parties has been duly considered from the arguments. The learned counsel also from the law reports stated above from the report available before the court is for the opinion that the right to be heard by the court is not an empty formality, but is by the right to life. Liberty of citizen and is a duty of the to inform regarding all the rights that include the right to make criticism to the said court unless the is from that is entitled to be presented to the Preventive Court with instead of effect. How will we ask for the same the appropriate authority? Example, the state government, central government, and Preventive Court. Mention get all information correctly of the government of the Preventive Court may go in further information it may be necessary for him is declared to the right person that has made to put this thing before the Preventive Court. The state law requires a doesn't indicate the right to make decision of a friend before the Preventive Court to represent himself before the Preventive Court with implication and or giving me the right to make decision before the Preventive. One missing of such government as it above may not indicate the organization, but the legal right of the to make an effective decision with the government with the Preventive Court is curtailed. which is protected under Articles 22 plus 5 of the Constitution in the effective date of the act. As the word and so therefore the proposal has a positive content in the matter of personal liberty, the need for observance of procedures have part, particularly in case of deprivation of life and liberty is of prime importance to the body politics. As a response stated, it is a duty of the authority to inform the authorized regarding his right under Article 22 plus 5 of the Constitution, which Section 8 of the act, doing to make dispensation against order of detention before appropriate to the authorities at such report. May right to be heard mentioned in the grounds of detention will be airs from the unless it is mentioned that the detainee has a right to make representation to the appropriate government, including official report with the assistance of his next friend and or by way of filing representation. For fairness, it is the duty of the detaining authority to inform the detainee regarding his aforesaid right and entitlement in his call of detention. If you wish concerning per 9 of the case of uninvolved and writing of the case of accused Ahmed Shukar can easily present the detainee the right to be heard. But the report either by filing representation in person, the assistance of his next friend may be heard in conference, the assistance of a friend, and in the same case, though in the of next friend to the friend in person is not in the same case, though in the ground number A of the detention, if maintained is right of being heard by the court, but the same is not enough as the word right to be heard does not exclude the right of the detainee to file a complaint to the board. The best court decided that the detainee should have to get assistance of his next friend before the board. The detainee has to be informed by the authority that he has a right to make representation, has a right to be heard in the right to do representation and hearing in person, and also he should have to get assistance of his friend before the board. The time when the detainee is to be heard. Personal mention in order and for such on name but the right to be made for the community represented the social part that is being said under the consent of 155 in the case as included the community detention that continue will be related legal and in the community detention the right to information in consideration thereof by the public committee the arrest time and through of next film of the detainee for within before the part and the second law the also for the ticket over detention and the supreme external vendors or order of detention illegal. So, my lord, the law that clearly stated that if these conditions are not met, the detention order is illegal, and the detainee have been detained illegally from the date of the passing of the detention order. It is 17 November 2025. And the confirmation order, if I have annexed in 858 petition order extend up to 18 May 2026.
Can you read last two lines in page 48?
You are also informed that you have a right to attend a personal hearing before the bid. Yes, if a report conceived by the government under the Associate 8. Decision of a friend must not mention. That's my bidding. And he is interest and he cannot present his case overly. Since to the extent of a friend. In the case that I relied the first stated decision of the friend is necessary.
When was the hearing of this advisory board held? Hearing before the advisory board was when?
So because it said on 13/1/2026. The report was submitted on 23/1/2026.
Yes, what do you say? All 3 points raised are good grounds to quash the detention orders.
Right to be. Because of the by the paralysis of the it's a fish.
Yes.
There is six. But with regards to the statement made in paragraph 7 of the petition, the answering proponent denies the same and further states that refers to show that the information provided to the detainee and acknowledged by the same, the detainee was informed of his right to represent against the detention to the detainee authority, state government, central government, as well as advisory board. The entire proceeding has also been videographed. I forgot to mention here that as per the records, there were 2 witnesses as per the record, giving out the and therefore the claim of the detainee also does not hold water. The detainee has been able to make an effective representation against the detention order and as such has not fallen short of constitutional mandate given in Article 5 of the Constitution. As far as this case is concerned, all procedural safeguards have been strictly adhered to, especially with regard to the timelines, your lordship, as mandated in the PIT and DPS, it has been minutely followed, your lordship. And as far as the subject satisfaction of the detainee authority is concerned, your lordship, the records could show that there were poison materials before the detainee authority. For example, the FIR that report, the CDR report, and the bank statement, bank analysis statements, your lordship, which corroborates with the evidence. These are corroborative evidence, your lordship, with regard to them. Of course, the admission will not be used against the petitioner, but the admission, your lordship. This was on the 3rd attempt of trafficking, he was arrested, your lordship.
That's not there in the detention order. Is it there?
Your lordship, that was not mentioned in the grounds of detention, but it was before the spent detainee authority, your lordship.
But if it's not there, it is prejudice.
Also, your lordship.
You would be prejudiced. You know the law.
Yes, your lordship.
He'll be prejudiced if you take that into consideration without giving him that material. In fact, we think in Nagaland you should be better than us in preventive detention laws. The amount of NSA cases you have dealt with.
The government was not arrested on all those occasions. He had admitted that he had trafficked on 3 occasions, and on the 3rd occasion he was arrested. But on the previous 2 occasions he was not arrested. And your lordship, on subjective satisfaction, I would like to rely on anything.
No, question of subjective satisfaction will not even come. His 3 grounds are: number 1, that there was no chance for bail because he never applied for bail. Second is that he had a right to assistance because he does not know, is not illiterate. And
all the documents, all the necessary documents was given to him. On those documents, he had signed in an English script, so that shows that he's not illiterate. He has studied up to class 5.
In one of the documents, he says that his mother tongue is Hindi. You've seen that? See the detention order somewhere. He is. When he has taken his consideration.
His mother language is mother tongue is Kuti, so we have explained him in Kuti language.
That is also not mentioned, I believe.
Your lordship is the records will show.
He has signed that receipt of being served. Where is that? Which page of your affidavit is that? And written form, it is written in Hindi.
That's regard as already there as 16. It's With regard to signature, you should have attended with the signature, it's in page 10, prior to December. With regards to the office.
No, his signature is there. There's no doubt about it. Signature is there.
It starts with annexure H1 reflect the pages, and the list of annexures and.
Okay, we look at the follow understand very easy. Consider this doctor. Let us visit class 5. School into that's 5 given.
Subscribe only in English of sign group I go.
Hmm?
That's fine, only English of sign group I go. Jiggy month I go with declaration. What? Still, if you don't presumption, I think with Mozilla. Since
Say this is same to you.
I always say, presumption is you understand something, so it's so otherwise.
The signature they can preserve the positive. Right.
That's right. Laws and
give Black's Law Dictionary. Black's Law Dictionary.
So we made an elaborate signature.
It's very complicated.
Okay.
Not a complicated. So we take as a hypothesis of process. Why fully it is of proceeding. So
No, no, Hindi take it as I understand signature. Hindi take it like I understand Hindi. Again. Multilingual.
it's okay, leave it. Leave it. That's what signature declaration is signature is a person made by him or his instructions panel. Coming more than 3 exam. At order to use it. Sign to the mark to preserve the mark to use down. Not the sign of this. It says it with my consent. It is with my signature. It's a mark of a man. Mark of a man.
By definition, there is a case where admittedly he has himself written his name in the English language. Only in that circumstance. How can you say that he doesn't?
It was before the party. I said he's class 5. It is this. Class 5 type of guy.
Plus 5 plus variation. I don't know what he would in the place where he did not go English.
It is like a literacy later. As I pan away, literacy is.
That's the definition to be a signature code like it is a definition of signature or the handwriting style to the Nagaland is in English.
Right. You had said three grounds. One is no chance of bail, right of assistance of a friend, and third was
Section 9C is also corrected.
section.
Section 9C.
What is that?
The advisory board need to submit its report opinion within 11 weeks from the date of detention. But here, my learned colleague has stated that the advisory board submitted its report on 23/1/2026. So that from the date of detention, it comes to more than 11 weeks. So on that ground, the decision order is very legal. I mean, we allowed to read out section 9C of the PNGSA.
He has not applied for bail. Does it also petrol lifted up assumption that there is no possibility of bail? He has applied for bail in many days. This is set aside. He can apply for bail.
If you have not applied for bail, then why are you challenging this order?
Because I'm illegally detained.
You'd anyway be in detention.
Big burden.
You'd anyway be in detention if you do not apply for bail. In that case, in the police case, in the NDPS case.
Before I apply.
No. Even if this order is set aside, detention order is set aside.
Be entitled to default bail if the detention order is passed.
You have already crossed.
Yes, no.
No charge sheet filed.
No.
So presently you are only behind bars only on the strength of this detention order.
Yes, sir. Section 9C.
Yes.
The advisory board will be reference display other clause P and after considering the reference in the material placed before it and after calling for such other information as may deem necessary from the appropriate government or for minutes or simple for the purpose of the appropriate government or from the person concerned, and if in any particular case it considered to do or if the person concerned desired to be heard in person of the hearing person prepared its report defined in a separate paragraph or whether or not there is nothing cause for the truth of the person concerned. And submit the same issue 11 weeks from the date of detention of the person concerned. So it comes to more than 20 weeks from the date of detention.
What is the date of detention?
17/11/2025. And the learned colleague has stated that on 23/1/2026, the report is submitted to the government, opinion of the advisory report. So it's come to more than 20 weeks now.
It starts with this, if we count the days, it's 11 days to 77 days. So if we count from 17 November 2025 to 23/1/2026, it's 68 days, Your Worship. So it is well within the timeline, Your Worship.
Default bail is a long way away, that means.
It is well within.
This may still file charge sheet within this time. So how do we entitled to default bail?
My prayer is that the detention is illegal.
We understand your prayer. We are putting to you a query to which your answers doesn't appear to be too accurate or factual.
No chance of delete it.
Declaration notice of the home, we use a default bill and the using PPS funding on the so he's only 68 days.
Nice if you go to 96 days, 98 days, 44. 1725. It makes basis. Expensive. Default is right that way. Hidden places, you know, they apply online, they buy 90 days, charge for hidden places. Now, people entitled to pay.
You want 80 days revision.
So, yeah, very about hospital. It's really sad. Habitual offender.
He is entitled to default now. How can I say no chance of bail? That way also they not chances in charge if I know that I'm an they'll be automatically out of bail.
It was not their consideration.
It was go to night most of the that was different. Out of legally if you were a Quran, it would still be. Page 47. Page 47. This one detail has information from the government using the global safety of boxes, human is second. That's compare again. This fully opinions are set for me regulation.
No, he was arrested on 26/6/25 in connection with that, what you call narcotic PS case number 8 of 2025. And you say that you never applied since 26/6/25. No, you never applied for bail.
No.
And you are certain search sheet has not been filed.
You have to find out.
Only after this order is passed, after the crossing of 180 days, I filed the full bill. But because of this, because of detention, the court had gave it open. The bill had not, it's not hard. The bill detention.
It should be a default bill, but the detention of the Tagi will wait to as far as that anticipation. Preventive detention is different.
Six months of the
Default bill pending, will be released automatically. Government had to go and now they say there is no possibility of. So how can it be said that there is no possibility of being bail once this is citizen?
Okay. We'll examine in pass orders. You'll come to know tomorrow morning. Today, by the time we deal with it, we'll not be able to upload the order. Your records are here.
I will just get the list of elections.
Ah. So just record the names of the council and Miss Inauli and council of the petitioner. Please give your names. You have to make inquiry tomorrow morning. Right.
For audits, item number 2.
You could chamber. Chamber.
I love the alternative struggle. And it goes over so time given up. That come of opportunity.
No, this is what you call his challenging the detention order. You can't adjourn it like that. If the authorities don't give you instructions, they are at fault. They want perhaps him to be released. For respondent number 1, we can't help it. Our rule says that normally endeavor should be made to dispose of as early as possible. In this case, the notice was issued when? 29/4/26. One week detail. We'll give you a week's time then.
My lord, I don't have any allegations against the central government. Only allegations are against the state government. Nothing against the central government. So if the central government is not heard, no prejudice will be costly. No prejudice whatsoever.
It's not a question of prejudice. It's a question of what they have to say in the matter. They may or may not say anything.
Your Lordship, if I may, the rewards have arrived, but Your Lordship, we need to find the affidavit. So if affidavit.
But you see, if you don't file, that means you want this man to be out. If in preventive detention, the authorities don't take it seriously, you can't do anything. You're bound to hear and take up the matter. If you want the administration to be strengthened, what we can do is that we can impose, in one case, we'll impose personal liability on the authorities who have not given you instructions. Ask the government to drop a disciplinary proceeding against him. And next time you will get all the instructions on time. At times we need scapegoats, right? In one case we'll do that, and in all cases you'll get instructions. So just name the authority and then say that disciplinary proceeding will run up. He should be taken off the charge till he files a reply, whoever he may be. You have to convince them. If they don't give you instructions, we can't detain this person. So far as the learned counsel is concerned, he is holding a brief. He has an urgency. And we can't tell him that you wait. He's holding a brief. He has an interest in early hearing.
You're watching the reports of it also. If mentioning that they have basing on the reports.
So you decide. We will not say anything. You decide. At best, we can adjourn it not more than a week from today.
Should be enough to file your affidavit. Why do you need more than a week?
But not more than that.
You watch it, you can take up the basing on the reports.
Okay. Yes.
Petition orders. Which the petitioner hearing is seeking for revocation of the interim detention order dated 23rd January 2026. The approval order dated 02/02/2026. And the confirmation order dated 14th April 2026. One of the petitioner is seeking for revocation of the information orders basically on two grounds now. My grounds are at para 7 of my petition memo. Page number 7, para 11. Page number 7 of my petition, para 11. My first ground is that the detention order dated 23rd January 2026. In the detention order, there is no mention that the detaining authority had reasons to believe that there is a real possibility that the detainee is likely to be released on bail. Here he has been under a serious section, and all the sections leveled against him are non-legal. Until date, the detainee has not moved for that. Therefore, the detention order was passed mechanically without the petition of law. And to support my contention, my God. Currently, I'm only to rely on a petition of this honorable court. WP Criminal 12 of 2023. In the matter of Nancy versus State of Nagaland matters. The relevant para is at para 15 million.
You see, same question we asked to the earlier counsel, same thing. If you don't apply for bail, how will the authority write that there's likelihood of being released on bail?
Yes, Honorable.
The question will never arise. Only when your bail application is there, then you can read and then tell whether bail will be granted under such circumstances or not.
Yes, Honorable. So, my Lord, even under regular laws, under the BNS, the MSR, the AMSEC, I have already been detained. So there is no need to pass the detention order. Passing this detention order is confirmed by right, even if I apply bail, the bail is
You're still not applied.
even if I apply bail and bail is granted or beyond the custody.
That is all anticipations. It may happen, it may not happen.
Yes, Honorable. So basically, mere apprehensions, my right under Article 21, basically mere apprehensions that I'm likely to use, that I'm likely to not apply. So the regular laws can keep me in prison. Therefore, the detention pass under national security it was mechanically passed, and which was violated by Article 21. But also to support my first contention, my Lord, can you allow me to read para 15 of the citation, my Lord? Para 15, page numbers 5, my Lord. The first point of determination which arises in the same proceeding is as to whether the person who is in jail can be detained under the detention law, taking into account that the husband of the petitioner hearing is already in judicial custody. In the case of Dharmendra Sukantram Tekawat versus Union of India, reported in Mount SC 026/1990. it was observed that an order of detention can be validly passed against a person in custody. For that purpose, it is necessary that the grounds of detention must show that the detaining authority was aware of the fact that the detainee was already in detention, and there are compelling reasons justifying such detention, despite the fact that the detainee is already in detention. So now, the Supreme Court further clarified the expression compelling reasons in the context of making an order of detention on a person already in custody to mean that there must be cogent matters before the detaining authority on the basis of which it may satisfy that the detainee is likely to be released from custody in the near future. That is the compelling reason which the detaining authority should mention in the detention order, based on which I have been detained.
But in detention under some other orders also.
No, my lord. Under NSA, National Security, I have been.
Only this one,
Yes,
only this one.
yes, my lord.
In this case, you were arrested when? What is the date of your arrest?
No, I was arrested on 29/12/2025. 29/12/2025.
9/12/25. Charge sheet submitted when?
So she knows that now.
Not yet submitted.
What is
This detention order was passed on
23 January 2026.
You were arrested under Arms Act 1A, 25(1)(a).
Yes, ma'am.
25(1)(a), what is the default bill period? 180 days, 90 days.
It is, ma'am. 60
1A, 60 days.
60 days, ma'am. 60.
So you have already completed that. 60 days is complete already.
Yes, ma'am. But I have been booked under other sections also.
Which is 90-day offense.
Yes, ma'am.
Which provision is 90 days? Which offense is 90 days bail? $140 is how much?
Next to 10 years, my lord. Section 140, kidnapping and abducting in order to
10 years,
murder.
so 90 days.
Yes, ma'am.
May extend to 10 years.
Yes, ma'am.
10.
It may not be 90 days. Minimum is not 10 years. May extend to 10 years to 60 days.
60 days.
Then my lord, 60 days.
So 127 is
127 is down from confinement, my lord.
So 60
okay,
days.
60 days. 308.
Yes, ma'am.
308.
308.
308 is extortion, my lord.
Punishment is how much?
It's 10 to
Will also be 60 days.
next to 10 years, my lord.
60.
60.
Next to 10 years.
porque esto lo de que lo estamos viendo lo que tal que This detention order was passed before expiry of 60 days.
A month.
Yes, my lord.
Yes.
And my lord, my second ground is that the detention order was passed on 23rd January 2026. So this makes that as per Section 10 of the National Security Act, the reference and the detention order and the detainee is to be produced before the advisory board within 3 weeks, as per Section 10 of the NSA. So the appropriate government ought to have produced the detainee on 14/02/2026.
Section?
Section 10 of the National Security Act, my lord. NSA, my lord. May I read, my lord?
Three weeks expires when?
It would expire on or before 14/02/2026, my lord. 14/02/2026. Latest by 14/02/2026.
And date of reference is?
21/02/2026. 21/02/2026. That was the date when the detainee was produced before the advisory board, my lord.
Production on, please give again, production on
21/02/2026.
21/02/2026.
That is grounded on, otherwise. What more to see?
My lord, to support my contention, I will be relying on the same citation at para 25, my lord. On the same citation at para 25, my lord.
Where is this 21/02/26 any order communication? The
Yes,
advisory board? 21/02/26.
Yes, my lord.
Any annexure?
No, my lord, I will inform my that it was produced on 21/02/2026. My lord, I believe the state will have the reports, my lord.
No, as per the report, it is 14th day he was produced.
Your Lordship, if I may, the date referred here is the date where the advisory had their sitting. The second ground taken by the petitioner, Your Lordship, it is misleading. Reference was already made to the advisory board on 6th of February. Annexure.
We don't know, we'll come to that.
Annexure B.
Dates will come to that. Confirmation, the passport please. State place the matter with the advisor court. Section, you can place the matter with the advisor court within 3 weeks. If you have received different documents and records, the matter place in by 14 day. Section, equal tenor. No,
At the place for see grounds or say state. Grounds, so that is represent.
no, it's there, you can see it. This place, yeah, green flag.
नहीं affidavit to broker so they मीशो है जरा पर एक करो ना सो दे affidavit to broker मीशो है उसकी about not a success.
No, something is wrong. Nine three sitting.
No, sitting 21 to report is not.
Yes, 6 people. This way, Sigma.
If it took
Something is wrong. I think we'll require your affidavit. It's not matching. The as per the statement of the counsel for the petitioner, the detention order is 23/1/2026. It is projected that on 6/2 the reference was made. Correct. You're not getting that. Just check up 6/2 whether the reference is available. You got it? This person, please get that.
It will make a petition.
We'll do this here. 6 to 8. So very low. Okay, 6-2. The document is there, page 126 of the record. So therefore, only one ground remains, that is the likelihood of being released on bail.
Yes, Your Lordship, if I may.
No,
on
he's
that-
not complete. He's not
No, my
complete.
lord. Once as per section 10, in here, yes, I filed my representation on 17/3. But what if I filed my representation, regardless of whether I filed representation or not, within 3 weeks, the sitting has to be done, my lord. If I file my representation and it's not disposed of within 3 weeks as per section 10, then also it will vitiate the detention order, my lord. As per section 10, my lord.
What is the date of your representation?
17/03/2026, my lord. After the sitting, only in this case, only after the sitting I filed, my lord.
That would fall outside section 10.
Yes, my lord.
What would
Yes.
it be covered by if you make the representation after 3 weeks?
Yes, my lord.
Then
That is there.
which
But
section will be
regardless
there?
of whether I make a representation or not,
Whether you make a representation or not, they have to place the grounds of arrest,
detention.
before the advisory board within 3 weeks.
Yes, my lord.
You did not make any, along with your representation, if any.
Yes, my lord.
If you don't make any representation, then without it, they have to place.
Well, regardless of whether I make a representation.
Yes, that is what we are saying. If you don't make a representation, even then they have to place it.
Yes,
before
my
the-
lord.
So it was
That,
done on
that is
6-2.
done. That was done.
That was done.
Well, I was produced only on, as stated by this thing, I was produced only on
Section 10
21.
does not mention any production.
Production. is not
Section
there.
11, section 11. Procedure of the advisory board. The advisory board shall, after considering the matter placed before it and after calling for such further information as it may deem necessary from the appropriate government or from any person called for the purpose to the appropriate government or from the person concerned, and if in any particular case it considers it essential to do, or if the person concerned desires to be heard, after hearing him in person, submit its report to the appropriate government within 7 weeks from the date of detention of the person concerned. My lord, to support my contention, kindly allow me to rely on the citation which I have already cited at para 25, my lord. At para 25, my lord. May I read, my lord?
So as per 11, advisory board is required to send to the central government, appropriate government.
Appropriate government. And also here, the detention, my lord.
If you so desire.
Yes, my lord.
So what happened within these 7 weeks? Nothing.
My lord, I am not aware when
No. You said the section says mention 7 weeks from the date of detention.
Yes, the report is to be submitted by the
Yes.
advisory board. within
So
7
what
weeks.
happened? Nothing was submitted.
My lord, I'm not aware of that. The copy was not given to me. The report of the advisory board was not given to me.
Actually, that is the problem. Once we don't take an affidavit, then everything
We have
becomes
to
our
find
burden.
out, yes, if we have
Everything becomes our burden.
every
That's very
section, whether
difficult.
it has been complied with or not, we have to check through the records.
Which every statement they will have to respond and we'll have to read the records. It doesn't simplify matters. You give it time, 1 week time we are giving to file an affidavit, because otherwise we'll have to look at the records. Every time he makes a statement, you respond and we have to look at records to verify. It's not the way to, yeah. And we'll forget. The problem is with this sort of records, we may tend to forget. And then either there will be an injustice here or you will be compelled to release a person. So we give a time. It's a week's time. We'll take it up next on 13th. All sides are represented. S. Mere Leonard, government advocate, submits that she has the records and is ready for the hearing. Full stop. The Leonard CEC had submitted that he is yet to receive instructions. So in this regard, the Leonard Counsel for the petition has submitted that there is no allegation against these central government, and therefore the matter can be heard. The matter can be disposed of by hearing the London State Council. Next para. Having heard the London Council for the petitioner for some time, it appears that an affidavit in the matter would be necessary by the state, as it is difficult to find out the relevant facts from the record. First, accordingly, the state shall file the affidavit positively by 12/5/2026, this from 13/5/2026.
Obliged, my lord.
You can take this back, and on the next date you can again place this. You've given us this addition.
Section 11 ground to plead করা নাই যদি report করা নাই
You
then
please
take that ground
you please record, since it is not in the ground about 11, that section 11. We did not find it in the grounds in the writ petition. So please note it that you'll have to respond to that also. Your pleadings, we did not find that. Section 10 and 11 ground, we did not find in your petition.
your pleadings and the section 10
Procedure to be followed by the advisory board.
But unless you say it, it's very difficult. That's why we had to send it back.
Yes, my lord.
So just note it, section 10 and 11 is not complied with. That's the main point.
Obliged, my lord. For hearing, item numbers 3 and 4. Lordship, I have read the bullet points in this case. Copies. Yes. After the
Last time when you were making,
last-
last time when you were making your submissions, you were at page 620,
my lord.
referring to the dismissal of the SLP.
Yes, my lord. And the writ petition which says that I am covered by the earlier decision.
Oh, just a moment.
$617, my lord. Page 617.
No, just a moment.
Otherwise, my lord, can we go to the bullet points?
Huh.
Much better, my lord. Go to the bullet points.
Yes.
The first one, my lord, the points for consideration: A, creation of posts under the Department of School Education, posts created and sanctioned by the Cabinet. First notification, which is at page 725 to compilation A, sanction for creation of 200 posts of graduate teachers under the Department of School Education. 2, notification dated 2010-2009, creation of 260 posts of undergraduate teachers under the Department of School Education. Then 3, notification dated 21/3/2011, creation of 2066 posts under the Department of School Education. 4, notification dated 15/6/2011, creation of 482 posts under various categories under the Department of School Education. I have given all the page numbers also, ma'am.
Yes.
Then B is advertisement. Advertisement dated 2011-2009, posts of graduate teachers under the Department of School Education advertised. Advertisement for regular appointments under the Department of School Education. This is the point, ma'am. The advertisements were for regular appointment under the Department of School Education. And C, appointment orders of the parents. The appointment orders of the parents are at pages 459 to 496 to compilation A. The appointment of the appellant number 1 specifically states that his appointment is under the establishment of the DIS of schools, Wokha. The contents of the appointment orders of the other appellants are similar. 2, the appellant's services have the facets of regular appointment under service books. All of them have service books. Deduction towards GPF and JS, all of them are contributing towards that. All covered by the old pension scheme. This is the 2010 employees. Then some of them have been granted MACP. I am told now, my lord, that all those who were appointed in 2010 have all received MACP now. From the dates of the initial appointment, they are now 16 years into service, almost 16 years into service. All of them have received MACP. Then, next page, my lord. They have been admitted to the benefits of the revision of pay rules 2017. Now, as far as all these facets are concerned, but also appreciate it, only regular government servants, persons appointed against sanctioned posts, can avail of this service benefits. No one else. No one else. So, more particularly the MACP, then the benefits of the revision of pay, only regular employees. Then the appellants are deployed posted in schools under the Department of School Education. They serve alongside others appointed to the same post, that is graduate teachers. Since their initial appointment, they have now been in service for about 16 years. Then, in the year 2013, some reservations were expressed in relation to the services of the appellants. The ANSTA, that is All Nagaland School Teachers Association, submitted queries dated 4/9/2013 under the RTI Act regarding the status of the appellant's service. By a response dated nil October 2013, the Department of School Education furnished replies stating that the posts held by the petitioners was created by the government and that they were appointed in regular basis, and further their service is not coterminous with the SSA mission. So this is page 498 of the compilation A. Can we go to this document, my lord? This document is quite telling. Page 498 to the compilation A. 497 is the query which was submitted. Compilation A in 278 in writ appeal 24, my lord. Compilation A in writ appeal 24.
Yes. Compilation A,
In writ appeal 24.
24.
Yes, my lords. Yes. Page 497 is the query which was submitted. Page 497, my lord.
Okay, of the second writ petition.
Yes, but this is the second. Yes,
Oh, achha, okay.
since that was the appointment in the year 2010, that's why we're starting with that now.
497, the seeking of information.
Yes, my lord. Yes.
Yes.
And this is an RTI application which was submitted on 4/9/2013. This is not long after the appellants were appointed, 4/9/2013, and this was submitted by the All Nagaland School Teachers Association. Page 497.
Yes, you have it.
To the PIO, State Mission Authority, SSA Nagaland, Kohima, seeking of information, kindly furnish the following information is under. How much amount of money has been sanctioned so far by MHRD for the salary of teachers appointed against SSA post creation? On what basis is the fund being sanctioned by MHRD, whether annually, half-yearly, quarterly basis? Whether the fund being earmarked for salary of teachers is being utilized for other purposes? If so, indicate the area where it is being utilized. What about the service security validity of teachers appointed against SSA post creation? Will their service still continue even after the project is over/ended? If the authority knows that the sanctioned money will be exhausted within 3 months, why has the authority failed to project salary requirements for the coming months and let the teachers suffer? The above information may kindly be furnished. Then the reply received by page 498. At next page, ma'am. The reply was received by page 498 and by the PIO in the Department of School Education. And the replies are at page 499. The answers, the responses to the queries are at page 499. First query, not very relevant, ma'am. 2 also not very relevant. 3 not relevant. And 4, what about the service security validity of the teachers appointed against SSA post creation? Will their service still continue even after the project is over/ended? Mention the response, ma'am, on the next column. Mention may be made that the post creation is not done by the SSA. Can you know that, ma'am? Is not done by the SSA. It is a government of Nagaland undertaking. Hence, teachers are appointed on a regular basis and their service is not coterminous with the SSA project. So this is the response which was given in the year 2013. Then, my lords, if you can go back to the bullet points again.
This is again page 498 and 499 is interesting for a different reason.
Yes, my lord.
499 does not have any signature seal or something, anything. It's just there.
499 now. Yes, it doesn't have any signature, but this is the response which was enclosed to this letter, which is 498. And my lord may note the body of the letter 498, the body of the letter with reference to the above mentioned subject. The information sought by you has been duly furnished. Kindly find attached response sheet.
Okay.
And in fact, in the affidavit filed by the state respondents in this writ petition, they acknowledge this. In fact, they also rely on it. But their interpretation of their response is that the posts were not created by the government, but the posts were created under the SSA. They've had to twist the language now by the affidavit. I'll come to that affidavit, my lord. It is there in my bullet points. Can we get back to the bullet points now again, ma'am? Yes, I'm now at note E in the second page. At note E. Seniority disputes amongst teachers. Seniority disputes amongst teachers. The decision of the government to allow graduate teachers appointed on temporary basis to count their seniority from the dates of initial appointment on ad hoc temporary basis and not from the dates of regularization in service was a subject matter in WPC number 214 of 2015. By judgment in order dated 1/9/2017, page 506 to compilation A, this Honorable Court held that contract ad hoc appointees can count their seniority only from the date of regularization, operative portion at page 615 to compilation A, paragraph 26. We've already gone through that in our chips on the last occasion. Then, appeals against the judgment in order dated 12/10/2019 were dismissed, pages 620, 698 to compilation A. Specialty petitions filed dismissed by orders dated 18/11/2021 and 2/2/2024, pages 413 and 414 to compilation A. Can we pause here for a moment, my lords? So the decision of this Honorable Court in these cases is that those who are regularized in service cannot rank above those who are appointed on regular basis. That is the decision. That is the decision. Then 2, on the same grounds as the petitioners in WPC 214 of 2015, the appearance filed WPC number 122K of 2017. The state conceded the case of the petitioner's appearance and accordingly by order dated 1/11/2017, page 617 to the compilation A, this Honorable Court held that the petition filed by the appellants is covered by the judgment and order dated 1/9/2017, passed in 214K of 2017 and WPC number 34K of 2016. So the concession was already there that the appellants who were appointed in 2010 are covered by the decision of this Honorable Court in writ petition number 214K of 2017. That concession was there. So we have a judicial order now, my lords. We have a judicial order which recognizes that the appellants appointed in 2010 have been regularly appointed. That judicial decision is already there. Can you make note of that, my lords? Then 3. By the judgment and order dated 1/11/2017.
It barely says this judgment if last time we read it.
My lord.
It only says that their seniority will be from the date of from a particular date.
Yes. So my lord, the context is this. There were those who were regularly appointed already in service, and there were those who were regularized in service. So the government took a decision to allow those who were regularized in service to count their seniority from the dates of their initial appointment on ad hoc basis. That was challenged. That was challenging. So those who are regularized can only count their seniority from dates of regularization.
Okay.
So those who were appointed on a regular basis, their seniority was protected. The appellants filed a similar case against the same seniority list, my lords. 2015 seniority list, which my learned friend was at pains to place before your lordship on the other day. That 2015 seniority list has been questioned set aside. We also filed on the same grounds. The appellants in this case, as writ petitioners, also filed on the same grounds, challenging the seniority list of 2015, saying that we are regular appointees and those who have been regularized in service cannot be placed ahead of us in the seniority list. The state conceded that we are regular appointees, and therefore those who are put ahead of us in the seniority of 2015, seniority list of 2015, cannot be placed ahead of us. That was a concession, my lord. That was a concession. And that concession now has the imprimatur of the Honorable Court.
The page, this 506 is that earlier order
Page 506, madam.
of comparison A.
Yes.
Is that earlier order where this writ petitions, it was held that seniority would be from the date of regularization.
Yes, madam.
And the next order you are referring to is page 620.
Yes, my lord. 620 is a writ appeal, my lord.
Writ appeal.
Yes.
And the writ petition is? Writ petition order is?
617, my lord. 617.
617.
That is
WPC
in the case of-
122.
Yes, that is
On
in the case of-
consensus, WPC covered by so and so.
Yes, my lord.
So what is the effect of this?
By the order of 1/11/2017 in WPC number 122K 2017, my lord, the writ petitioners in WPC number 122K of 2017, some of them are the appellants in this case. So they were the writ petitioners in 122K of 2017. They challenged the same seniority list as 214 of 2015. And their case in 122K of 2017 was that they are regular appointees appointed in the year 2010. The appellants in this case, my lord. They are regular appointees appointed regular employees in the service of the state government as graduate teachers, my lord.
Yes.
And they were appointed through the selection process in the year 2010. Therefore, those who were regularized in service, they cannot count their seniority with effect from the dates of initial appointment and be placed ahead of them in the seniority list of 2015.
Therefore, seniority is on date of appointment.
Yes, madam. On the date of regularization.
No, you said that you are regular.
Yes. So, Your Lordship, what is the point is this: our status as regular employees was accepted from the year 2010.
So it will be seniority is on date of appointment.
Yes, my lord. From the dates of initial appointment. Yes, near 2010. Near 2010. Can we go to 3 now, my lord? At the bottom of the page. By the judgment and order dated 1/11/2017 in WPC number 122K of 2017, the appointment of the appellants on regular basis in the year 2010 was sealed with the imprimatur of this honorable court. The order dated 1/11/2017 has attained finality, and the appointment of the appellants on regular basis with effect from 2010 stands countenanced by a judicial order of this honorable court. That is my case, my lord. That is my case. And 4, WPC number 174K 2018 was filed by teachers. Now, this is another case now, my lord. Now, this is by a group of teachers who were appointed specifically for the scheme, under the scheme. And their terms of appointment was in accordance with the scheme. They were paid fixed pay, and their appointments were specifically made with the condition that their appointments are coterminous with the scheme. The petitioners in this case. This is another case, my lord. Kindly note the difference, my lord. WPC number 174K 2018 was filed by teachers who were specifically appointed to post under the NSA with the stipulation that their services are coterminous with the mission. Their claim was that since they were appointed under the SSA like the appellants, so they claimed pay parity with us because we were enjoying the regular pay scale as regular government servants. Their claim was that since they were appointed under the SSA like the appellants, they should also be given scale pay instead of fixed pay. This case finally came to be decided in writ appeal number 9 of 2020. In this case, the state categorically averred that the petitioners cannot claim parity as the instant appellants were appointed through a selection initiated by the Education Department and not by the RMSA, and that their scale of pay and permanence nature of service is mentioned in the advertisement. The findings of the division bench in this regard are in paragraphs 9, 10, and 11 of the judgment and order dated 16/3/2022 in writ appeal 9 of 2020. Now, incidentally, my lords, after the writ appeal was disposed of, the state took it in appeal. In this case, the state took it in appeal to the Supreme Court. The Supreme Court dismissed the appeal. In this case also, now. So, can you go to this judgment now, Your Lordship, at page 739? page 739. Is the starting of the judgment, and the relevant paragraph is at page. Relevant paragraphs are at page 783. Paragraphs 9, 10, and 11. Paragraph 9 and 10, my lords. May I read these two paragraphs, my lords? At page 783. 9, 10, and 11.
Yes.
The sanction of creation of the post by notification dated 28/10/15 and appointment of the petitioners against those posts has not been disputed by the state. It is also not disputed that similar process of temporary creation of posts was done in all the SSA and RMSA appointment. The fact that teachers appointed prior to and subsequent to the petition under SSA and RMSA were treated as state cadres living behind the petitioners by office memorandum dated 5/10/2018 is also not disputed. Now, this memorandum is also interesting, my lord. And though it is not part of this compilation, I have the copies. I'll produce after I read these two paragraphs. 5/10/2018. Can you note this memorandum? Office memorandum dated 5/10/2018. Then 10. The stand taken by the state respondents in their affidavit and opposition in brief relating to the present issue is that though by the notification dated 18/10/2015, sanctions for creation of temporary posts were accorded and that the appointment of petitioners were also made against those posts. However, as I said, notification itself stipulates the terms and conditions of appointment shall be made in the appointment order, and the state government will not be responsible for their salaries, including future service carrier of appointees. Therefore, the petitioners cannot claim the scales of pay stipulated in the notification dated 28/10/2015 as a matter of right. 11. It is the case of the state respondents that other teachers with whom the petitioners are claiming parity were appointed through the process of selection, that is us, my lord, initiated on the basis of a separate advertisement, and the advertisement relating to those appointments itself declares scale of pay and their permanent nature, and those advertisements were made by the education department and not by the RMSA. According to the state, those appointments were not contractual, unlike the petitioners. Therefore, the state claims that there cannot be any parity of scale of pay between the petitioners and the other teachers appointed in schools under the RMSA SSA. So this was a categorical stand. We were appointed through a selection process initiated by the school education department. These other writ petitioners in this writ petition, they were appointed under the scheme through the RMSA. That was a categorical stand. So in two proceedings before the Supreme Court, the state has come out with a categorical stand that the appellants are in the state cadre service. They are not employees who are appointed specifically for the SSA. Now, this is the difference between the appellants, my lords, between the appellants and the petitioners in the authorities which the learned single judge relied upon to dismiss our case. My lord, this is the singular difference. Kindly make a note of this point, my lord.
What did you say?
My lord, the state respondents themselves conceded in two previous proceedings, took the stand in two previous proceedings, that we are employees of the education department, appointed through a selection process, appointed under the school education department, and we were made to serve under the school education, under the SSA mission. And though a part of our salaries during the existence of the mission will be borne by the funds received on the remission. Our services will continue even after the mission is wound up. So what I am saying, my lord, is this factual circumstance in respect of the appellants is something which is markedly different from the facts and circumstances in the authorities which the learned single judge relied upon to dismiss our case. And this marked difference in the nature of our service, in the nature of my service, has been taken note of in two judicial pronouncements, my lord. In two judicial pronouncements. And both these judicial pronouncements have attained finality. That is one, my lord. And in both these previous repetitions, a point which is ancillary to the judicial pronouncements, my lord, or which supplements the judicial pronouncements. The state themselves have taken in two previous writ proceedings that we are regular government servants in the service of under the education department. A factual assertion which has been taken cognizance of by this honorable court. Then can we continue, my lord? I was referring earlier, my lord, to the 3rd October 2018, which is reflected in this judgment of the division bench also, my lord. This is an office memorandum, and it reflects the decision of the cabinet held on 3rd October 2018. May I read, my lords? This is dated 5th October 2018. Now, this is prior to the mainstreaming exercise. Can you know that, my lord? Prior to the mainstreaming exercise, which is impugned in the writ petition. This is prior to the mainstreaming exercise. The undersigned is directed to forward herewith an extract of the minutes of the cabinet meeting held on 3/10/2018 for kind information and necessary action. Agenda number 1, issues relating to SSA and RMSA. The cabinet deliberated on the report of the committee constituted to look into the matters relating to SSA and RMSA teachers of 2010 and 2013 batches, which are the appellants in the two writ appeals, my lord. As per the decision taken in the meeting held on 26/10/2018 and decided in principle to bring teachers of the 2010 and 2013 batches of SSA and RMSA teachers into the mainstream of the school education cadre, with the condition that all the schools will be linked with biometric attendance and linking of Aadhaar number of all teachers will be linked to the same, which has also been decided by the cabinet on 8 March 2018. The cabinet also directed the department to club merge all the neighboring schools which are not performing or producing nil or have negligible enrollment. Further, the cabinet directed the department to frame guidelines or find a feasible solution to give golden handshake to the teachers who are underqualified or untrained teachers. Now, in the judgment of the division bench, the division bench has taken note of the fact that 2010 and 2013, a decision has already been taken to bring them into state service, excluding the petitioners in that writ appeal. Now, why I am trying to raise this, my lord? There are a huge number of contractual teachers, temporary teachers who are regularized in service. And the records will show, my lord, that there have been concerted efforts from time to time to try and give these regularized teachers seniority over other teachers. So through one process or the other, through one means or the other, the state respondents appear to be doing everything in their power to give seniority to these teachers who have been regularized in service ahead of those who have been selected through the selection process. So one such exercise again, my lord, apparently something was done in the year 2018. But 2018 was again superseded by the actions which were impugned in the writ petition for which this appeal lies. That is the point I'm trying to make, my lord. Then the writ petition now, my lord, add note F. Note F. In the bullet points, my lord. In the bullet points. F. The appellants as a petitioners challenged as the petitioners challenged. 1. Cabinet decision dated 21/4/2022, page 704, 705, 2. Compilation A. When you go to compilation A, Manoj, page 704, 705.
Be careful.
704 is the original copy, Manoj. 705 is the typed copy. Have your lordships got it?
Yes.
705. This is a cabinet decision dated 21/4/2022.
Yes.
The undersigned is directed to forward herewith an extract of the minutes of the cabinet meeting held on 21/4/2022 for kind information and necessary action by the concerned department. Agenda number 3, proposal for mainstreaming SSA and RMSA teachers 2010 and 2013 batches into school education cadre. Now, your lordships, to overcome all that has been done in the past and to overcome the judicial decisions which are already there and to give benefit to those whom they intended to give the benefit to, they came out with this mainstreaming exercise. Mainstreaming exercise. So this is what one of the actions that are impugned, and of course the other actions are the consequential actions. The next is the notification dated 2/9/2022 pursuant to the aforesaid cabinet decision, mainstreaming into the school education cadre with effect from 21/4/2022, page 706. May I read, Manoj? Next page, 706. 2/9/2022. In the interest of public service, the Governor of Nagaland is pleased to notify the mainstreaming of 2,290 educationally and professionally qualified teachers as per the NCT norms appointed under erstwhile SSA and RMSA of 2010 and 2013, batches into the state education cadre with effect from 21/4/2022. So by this action, my lords, we were mainstreamed into the state service with effect from 21/4/2022, which means we lost about 12 years of our service. 21/4/2022. By this so-called mainstreaming exercise, my lords, our date of entry has now been converted into 21/4/2022.
Please come again.
Has the lordship got the date 21/4/2022? In the middle of the first paragraph, my lord. Third line from the bottom. 21/4/2022. In the first paragraph, my lord. In the first paragraph. In the interest of public service, the Governor of Nagaland is pleased to notify the mainstreaming at page 706.
Yes.
Of 2,290 educationally and professionally qualified teachers as per NCT norms appointed under erstwhile SSA and RMSA of 2010 and 2013, that is the appellants, batches into the state education cadre with effect from 21/4/2022. So now, by this so-called mainstreaming exercise, everything that was done from 2010 was undone. And my date, our dates of entry into service has now been taken as 21/4/2022.
Yes.
Then the next one is number 3, notification dated 27/9/2022, wherein at clause 6, it is stipulated that teachers appointed recruited under 2009 shall be incorporated into the seniority list only after verification of claims. Now that is at page 707. Page 707, my lord. Yes. Clause 6. Notification date 27/9/2022, clause 6. The lordship got clause 6. Teachers appointed recruited after 2009 shall be incorporated in the seniority list only after clarification, rectification of dates, verification of claims. This phase-wise issue of graduate teacher seniority list has been necessitated to expedite the process of finalization of seniority list of graduate teachers as per the direction of the Honorable Court and to enable and effect promotions to eligible senior graduate teachers. So they couched with the language that it is as per the direction of the Honorable Court. But in the process, the directions of this Honorable Court have been ignored and flouted. In the process, my lord, the decision of this Honorable Court has been overturned by the mainstreaming exercise, the decision at page 705, and by the notification at page 706, the judicial decisions of this Honorable Court have been overturned. Then, if your lordships can come back to the bullet points, my lord. Number 4, at the bottom of the page. The state filed its affidavit in opposition, page 1714 to the compilation A. The stand taken by the state is reflected in paragraph 2. This is also very interesting, my lords. Can we go to page 714 now? Page 714 is the affidavit in opposition. Paragraph 2, the stand of the state respondents in the writ petition. Page 715, and my lords got page 715. Page 715, my lords, paragraph 2. That before answering the arguments made in the writ petition, the deponent desires to highlight the brief facts of the case for convenience and proper adjudication of the case. In 2010 and 2013, on the basis of the number of posts sanctioned by the Government of India, look at the language, my lord, sanctioned by the Government of India, it was not sanctioned by the Government of India. False statements. The state itself sanctioned the posts. The two centrally sponsored and SSA and RMSA, the cabinet created 462 posts of SSA and RMSA. 3,404 posts were notified under 300 and 3,334 posts were advertised. These posts under SSA and RMSA were to be co-terminus with the schemes. Again, another false statement by lords. The notifications which they rely on are the same notifications which I have already drawn your lordship's attention to. Whoever has filed this affidavit, my lords, is guilty of filing a false affidavit. In paragraph 2, Roman 2, my lords. Recruitment was done through district level committees in all the districts headed by the deputy commissioners. Appointment orders were issued in 2011 and 2013, and these teachers were given scale of pay, graduate teacher, primary teachers. In the case of SSA batch of 2010, the department indicated that after the scheme winds up, salary will be borne by the state. Now, a contradiction. They're trying to get the best of both worlds, getting something from here, something from there, and trying to make a case. In the process, filing a false affidavit. Next page, my lords, in the affidavit. These teachers of SSA, RMSA demanded they be mainstreamed into the school education cadre of the state government. Now, it is now, the case is now being presented. It is as if we are the ones who demanded that we should be brought into the state cadre. 4, based on the recommendations of the committee headed by the Chief Secretary, constituted to study the nature of the recruitment and appointment of these categories of teachers, the state cabinet in its decision on 5/10 agreed in principle to mainstream SSA and RMSA teachers of 2010 and 2013 batches into the state education cadre. Now, the point for consideration here, my lords, all these actions were taken after the judicial decisions of this Honorable Court were already there. And 5, The PNR department accorded clearance and finance department accorded concurrence for their mainstreaming, with the observation that the state exchequer will be burdened with additional financial liability to cover the shortfall on the salaries for these teachers. On the basis of authentication of professional/educational documents, police verification of antecedents of the SSA Army teachers 2010 and 2013 batches, the cabinet approved mainstreaming of the batches 2010 and 2013 batches qualified and trained teachers into the state cadre on 21/4/2022, and the mainstreaming of 2,292 educationally and professionally qualified teachers was notified on 2/9/2022. Now, after this, my lord, then in paragraph 10, page 718, your lordship, of the same affidavit. In paragraph 10, the earlier reference to the RTI application which I was making, your lordships, paragraph 10, at page 718. Paragraph 10. Yes. That with regard to the statement made in paragraph 9 of the petition, the deponent states that it is apparent from the affirmance in the petition that the petitioners have full knowledge of their appointment made against the SSA created posts, for which the petitioners had the apprehensions that they would not be included in the seniority list of graduate teachers of the school education department, and for which they sought information on the RTI. Further, the RTI reply dated 3/9/2013 states, now this is the same RTI reply, and your lordship was observing that there is no signature, but this is better than the signature now, my lord. It is now an affidavit. It's now an affidavit. And the reply there on the next page, my lords, at page 119. Mention may be made that the post creation is not done by the SSA. It is a government of Nagaland undertaking. Hence, teachers are appointed on a regular basis and their service is not coterminous with the SSA project. Very clear, my lords. Right from the beginning, in the two previous proceedings, they have admitted it. Now they are trying to adopt a very novel approach to try and deny it. But at the same time, there's no such thing as a perfect crime, my lord. The records speak. And in paragraph 10, they themselves again admit that these are posts under the state service and these are not posts under the SSA coterminous with the scheme. Then the bullet notes again, my lord. Paragraph 5. The averments of the appellants in paragraph 15 of the writ petition that the appellants are covered by the judgment and order dated 1/9/2017 in WPC number 214 of 2015 is admitted by the state respondents. Now kindly look at paragraph 15 of my writ petition, which is at page 415, my lord. The writ petition starts from page 415. And paragraph 15 is at page 434, my lord. Page 434. Page 434. Yes. Paragraph 15. May I read paragraph 15, my lord? This is relevant. Paragraph 15. That when the matter was thus situated, since the issue involved in WPC number 122K of 2017, filed by the instant petitioners and others, was similar with that of the issue of in WPC number 214K of 2015 and WPC number 34K of 2016, on the submission of the state respondents. Now again, your lordship will see, on the submission of the state respondents, the judgment which says that we are covered by the decision of 214K says it is a concession, it is a consensus submission. But in this paragraph, I am saying it was the submission of the state respondents. And in fact, it was a submission of the state respondents. On the submission of the state respondent, since the common judgment and order dated 1/9/2017 in 214 and 34 squarely covers the case of the instant petitioners and others, the writ petition filed by the instant petitioners and others were disposed of by order dated 1/11/2017, with the observation that the above common judgment and order dated 1/9/2017 squarely covers their case. So what is the response in the government affidavit to this paragraph, my lord? Kindly come back to page 719. Page 719, Bala. Has your lordships, have your lordships got page 719? This is the government's affidavit now.
Please repeat again. I'm missing that point. Please repeat again.
Your lordship, in paragraph 15, the incident petitioners, some of them, they filed WPC number 122K of 2017, and during the pendency of that case, the state respondents, they came out and said that WPC number 122K of 2017 is covered by the judgment in WPC number 214K of 2015. That is the point, my lord. Now, the response of the state in relation to paragraph 15 is at page 4719.
Yes.
Page 719. Paragraph 12. It is all a part of the records, my lords. But to have the same affirmed by affidavit, that is even much better, my lords. And at paragraph 12, page 719.
No, that was query was at that statement in petition was at page?
At page 434, paragraph 15.
Yes.
And the government's response is at page 719.
719.
Paragraph 12.
Yes.
At the bottom of the page, Lordship will see that the statements made in paragraphs 11, 12, 13, 14, 15, and 16 of the writ petition are admitted to the extent borne out by the records. So the state itself admits that in WPC number 122K of 2017, the state itself submitted that the appellants are covered by the decision in 214. Then, bullet notes again, my lords. At note G.
Since I have a weak memory, I mark it.
Very well, my lords. Yes. We are very grateful for a thorough exercise in your lordship taking me to this case, my lords.
Yes.
Can we go back to the bullet points, my lord? Note G. Bullet points, note G. And with this and the authorities, I will conclude my submissions, my lord. Note G, the impugned judgment and order dated 10/6/2024 in WPC number 278/2022. The learned single judge did not take into account the judgment and order dated 1/9/2017 in WPC number 214K of 2015 and the judgment and order dated 16/3/2022 in writ appeal number 9/2020. Therefore, so your lordship, it's not just 214K, your lordship, it should also be 122. Your lordship, it should also be the judgment and order dated 122, your lordship. 122.
One 17. 111/17.
Yes. So 122 of 17 should also be here, my lord. Pardon me, my lord. My apologies. I meant to mention it. So that judgment should also be here, my lord.
Judgment.
Dated.
111/17.
Yes, my lord. Keep it the judgment date. 122. 1/11/2017 in WPC number 122.
122/17.
Yes, my lord. Therefore, the judgment and order dated 10/6/2024 is per incurium. Your lordship, there was already 2 judicial orders which took into consideration the status of the appellants as regular government servants under the Education Department. These two judgments were not taken into consideration by the learned single judge. That by itself renders the entire judgment peremptory. Then, 2, the learned single judge dismissed the writ petition on the basis of decisions of the Honorable Supreme Court, which were clearly distinguishable. Facts, my lord, facts are different. Your Lordship knows as far as the applicability of judicial proceedings are concerned. Facts may be different. And even a slight difference in one single fact may render a decision inapplicable. In our case, my lords, sanction was created by the government. Permanent posts were created by the government. These posts were deployed to the mission authority, and with the clear condition, with the clear term, that even if the mission is wound up, the posts will continue. This is a factual circumstance which is different from all the facts in the authorities relied upon by the learned single judge. Then, 3, the learned single judge did not consider that the state has the power to create permanent sanction posts even for fulfilling objectives of mission projects. There is no law that states that for mission projects, only temporary posts must be created, quote terminus with the same. Earlier, your lordships will recall, when I first began my submissions, this is the point I tried to make as a fundamental flaw in the reasoning of the learned single judge, with all the greatest of respect. Then 4, what is not permitted directly cannot be permitted indirectly. The mainstreaming exercise is an attempt to commit this illegal act. So there are judicial decisions now, my lords, which hold that the petitioners have been in service, the appellants have been in service from 2010 in this case and 2013 in the other case. So by this mainstreaming exercise, the government is actually sitting in appeal over those decisions, my lords, and reversing them effectively. Is that a course of action which is constitutionally permissible, my lord? It is not. That is the point I'm trying to make in this 4th bullet point, my lord, in relation to the impugned judgment.
Which page was that impugned judgment?
Pardon me, my lord.
Impugned judgment is a page?
Impugned judgment is in the memo of appeal, my lord. It's in the thinner volume. Impugned judgment is that after the synopsis, my lord, is an extra one. Okay.
Yes.
And point 5, my lord, in the note on for the impugned judgment in order, bullet point 5, the petitioners were promised regular appointment and the said promise was fulfilled. So it is not only a question of promise not being fulfilled. Promised, we applied, we were appointed, the promise was fulfilled. After fulfilling the promise now, my lord, the state is now trying to backtrack. Therefore, the state cannot be permitted to backtrack. This is the point which I'm trying to make now. Now, during the pendency of the writ appeal, my lord, some subsequent developments took place. And so I filed an additional affidavit. It was filed on 2/5/2026. Have your lordships, do your lordships have the additional affidavit on 2/5/2026?
Yes.
Now, your lordships,
Just one minute. Listen.
Yes, you can start. I'll catch up.
very well.
No, just a moment. Just close it. Close it. No? Yes, now you After the petition. After the petition. Another bundle. It is. Is it based on no, it's.
Yes.
Your Lordships can turn to page 2 at paragraph 3. After all the facets of regular service which I referred to in my bullet points, my lords, after the disposal of the writ petition, during the pendency of the writ appeal, notifications were issued confirming the services of the appellants in relation to their dates of initial appointment in the year 2010. I filed this additional affidavit. After I filed this additional affidavit, another corrigendum was brought about, and they corrected this corrigendum. And the corrigendum now brings us back to 21/4/2024, the mainstreaming exercise. So these are the, yes, 2022. So these are the two additional affidavits, just to place that before your Lordships. And so I'm asking that the second additional affidavit which I filed to place the subsequent developments on record also be taken into consideration by the Honorable Court, by your Lordships, and appropriate orders be passed therein. Your Lordship, once a basis goes, everything else goes. That's a settled principle of law. So I have brought this on record by way of additional affidavit. Now, the list of authorities which I wish to rely upon, your Lordships. There's no need to refer to the books, my lords. I have mentioned the authorities and the principles which I've colored from these authorities, my lord. The first one is the about a consent order.
So apparently it appears that educating the education department was became fatal.
Contemporary for us, my lord. And that is what happened in the other writ petition, my lord, which became more or less baseless because of the corrigendum. I had to withdraw with liberty to file afresh. In relation to the limited departmental examination, your Lordship will recall the other day. So the first one, my lord, AR 1956, Supreme Court 1-346. This is about a consent order. A consent order operates as a stopper. It bars any of the parties from raising the same issue again. Your Lordship is well aware of this principle. Then 2 is Roshan Lal Tandon. Your Lordship was inquiring about, the other day, your Lordship was mentioning about the contractual nature of work. And my lord, I was trying to make this a point that insofar as public service is concerned, there is a difference. So these are the authorities on that point, my lord. The second one, the 1966 Supreme Court, Roshan Lal Tandon. Then 3 also, my lord, on the same point. So can we just go through 2 once, my lord? Can I read authority number 2, my lord, the principle? The origin of government service is contractual. There is an offer and acceptance in every case, but once appointed in his post or office, the government servant acquires a status and his rights and obligations are no longer determined by consent of both parties, but by statute or statutory rules which may be framed or altered unilaterally by the government. In other words, the legal position of the government is more of status. Legal service of the government servants, I have missed out a word there, Madam, is more of status than of contract. The hallmark of status is the attachment to a legal relationship of rights and duties imposed by public law and not by mere agreement of the parties. In the language of jurisprudence, status is a condition of membership of a group of which powers and duties are exclusively determined by law and not by agreement between the parties concerned. 3 also on the same point, my lord.
So is this in relation to the query on specific relief act?
Yes, my lord. Yes, my lord.
Section 14.
Yes, my lord. And 4 is subsequent developments.
But I think this Roshan Lal Tandon,
My lord.
I wanted from a point here, this was disciplinary proceedings.
Yes, my lord.
So disciplinary proceedings, one appointed either permanent or temporary.
My lord.
But once though appointed through contractual employee, but if he's there in service, then he gets the protection of 311.
Yes, my lord.
That was the issue involved.
Yes. So the same thing here, because we are also all regular appointees, my lord. We're not temporary.
But the query we posed was on the ground that if the appointment order refers to as order and a scheme, then perhaps it's a contractual not on the basis of that, but under section 14(1)(d) of the specific relief act.
Your Worship, that query particularly was in relation to something, a contract which is terminable in relation to the 1 month notice. On that also I have another decision. Then 4, my lord.
You are saying that you are not a contractual, you are
Yes.
appointed permanent.
You are a government servant? Yes.
Servant.
So the rules of contract does not apply to me strictly. That is what I'm saying, my lord. 4 is about subsequent developments, my lord, and there's no need to.
This Roshanlal Tandon again, I think, is a constitutional
judgment. Yes.
And it is being followed all throughout.
Yes, my lord.
Up to now it is being followed.
Yes, my lord. 4 is about subsequent developments, my lord. And 5 is in relation to the earlier judgments of the Sample Court. Then 6 is about the action of the state now, my lord. 2010 SCC 166, state cannot blow hot and cold in the same breath on its own issue. On the same issue, it should be, my lord. The state cannot take a different stand with respect to the same issue, especially when a previous proceeding has judicially concluded. 7, it is an elementary rule that a party litigant cannot be permitted to plead inconsistent positions in court, to play fast and loose, to blow hot and cold, to approbate and reprobate to the detriment of his opponent. This doctrine applies not only to successive stages of the same suit, but also to another suit other than the one in which the position was taken up, provided the second suit goes out of the judgment in the first. So we're still connected with the same case, my lord, and different stands in every different proceeding. And 10, this is our own decision, my lord. The government cannot take a stand which is contrary to its own conduct. And 9, the quotable in law is avoided and ignored if it is rendered in ignoratium of statute or other binding authority. This is about per incurium, my lords. Then a decision or judgment can be per incurium any provision in a statute, rule, or regulation which was not brought to the notice of the court. A decision or judgment can also be per incurium if it is not possible to reconcile its ratio with that of a previously pronounced judgment of a co-equal or larger bench, or if the decision of a high court is not in consonance with the views of the Supreme Court. So there was already an earlier decision. Say 11 is also on per incurium, my lord. Then 12 is also on per incurium. Then 13, the respondents are bound by the principles of promissory estoppel. This is my note, my lord. The actual decision is in the second paragraph. Taking note of the promise of regular service to the appellants with all its benefits, the appellants participated in the selection process and altered their positions. By resorting, as such, the state cannot be allowed to go back on the said promise by resorting to the mainstreaming exercise. A plea of promissory estoppel can be set up by a person against the state only when he is able to prove with adequate evidence that the state has promised him in writing express terms to grant specific benefit, and acting upon such promise he has altered his position. In such situation, the state cannot be allowed to go back to the promise made to such person, and he can enforce the promise made to him. Then, next page, my lords. Validity of the order impugned has to be tested on the basis of reasoning contained therein, and the authorities are not supposed to supplement the same by means of extraneous material or affidavit before courts. Now, why I am saying this, my lord, why I am relying on this authority, is because of the post-creation orders, the advertisement, my lord. The post-creation orders and the advertisements clearly lay down that these posts are the posts under the State Education Department. The advertisement clearly states that I will be appointed to a regular service. That now cannot be changed. This is the point I'm trying to make. And that now cannot be explained away by affidavit. And given the fact that there are already 2 judicial pronouncements on this issue, that renders it more absolute for the respondents not to resort to such kind of an exercise. Then 15, a decision is an authority for it decides. This is about the decisions which the single judge is relied upon. Then on the point of that 1 month notice, on the issue of that 1 month notice. Now, in this case, my lord, in the railway department, in the rule itself, there was provision for termination of service with notice. And your lordship will find that in paragraph 6. Paragraph 6. And this is also, my lords, a constitution bench judgment and rendered various back as in 1963.
One of the leading judgment on the.
Yes, my lord, it is one of the leading judgments. Paragraph 6, my lords. At this stage, it would be convenient to refer to the two rules. Rule 148 deals with the termination of service and periods of notice. Rule 148.1 deals with temporary railway servants. Rule 148.2 deals with apprentices. And 148.3 deals with other non-pensionable railway servants. It is with Rule 148.3 that we are concerned in the present appeals. It reads thus: 3. Other non-pensionable railway servants. The service of other non-pensionable railway servants shall be liable to be termination on notice or other side for the periods shown below. Such notice is not however required in the case of dismissal or removal of as a disciplinary measure after compliance with the provisions of clause 2 of Article 311 of the Constitution, retirement or attaining the age of superannuation and termination of service due to mental or physical incapacity. So this rule was challenged, my lord. And paragraph 26. Worships have got paragraph 26, the first paragraph, which I like to rely upon. Paragraph 26. Reverting then to the nature of the right which a permanent servant has under the relevant railway rules, what is the true position? The person who substantially holds a permanent post has a right to continue his service, subject of course to the rule of superannuation and the rule as a compulsory retirement. If for any other reason that right is invaded and he is asked to leave his service, the termination of his service must inevitably mean the defeat of his right to continue in service, and as such, it is in the nature of a penalty and amounts to removal. In other words, termination of the services of a permanent servant, otherwise than on the ground of superannuation or compulsory retirement, must per se amount to his removal, and so, if by Rule 148.3 or Rule 149.3, such a termination is brought about, the rule clearly contravenes Article 311.2 and must be held to be invalid. Then, paragraph 33, my lord.
Paragraph
33.
33.
Right. There is one more point which still remains to be considered, and that is the point of construction. The learned Additional Solicitor General argued that in construing the impugned rules 148.3 as well as 149.3, we ought to take into account the fact that the rule as amended has been so framed so as to avoid conflict with or non-compliance of the provisions of 311.2, and so he suggests that we should adopt that interpretation of the rule which would be consistent with Article 311. The argument is that the termination of services permissible under the impugned rules really proceeds on administrative grounds or considerations of exigencies of service. If, for instance, a post held by a permanent servant is abolished, or the whole of the cadre to which a post belonged is brought to an end, and the regular servant services are terminated in consequence, that cannot amount to his removal because the termination of his services is not based on any consideration personal to the servant. In support of this agreement, the ASG wants to test the provision contained in the latter portion of the impugned rules. We are not impressed by this argument. What the latter portion of the impugned rules provide is that in case a railway servant is dealt with under that portion, no notice need to be served on them. The first part of the rules can reasonably and legitimately take in all cases and may be used even in respect of cases falling under the latter category, provided, of course, notice for a specified period or salary in lieu of no such notice is given to the railway servant. There is no doubt that on a fair construction, the impugned rules authorize the railway administration to terminate the services of all the permanent servants to whom the rules apply merely on giving notice for the specified period or in payment of salary in lieu thereof. And that clearly amounts to the removal of the servant in question. Therefore, we are satisfied that the impugned rules are invalid inasmuch as they are inconsistent with the provisions contained in Article 311.2. So that clause is invalid, my lord. And not only that, but they can be just turn to the first appointment order at page 159, my lord. 459, my lord. One sample. Page 459. Type copies at page 460.
Yes.
Clause 3 of the appointment order. Worship has seen this, clause 3.
Yes.
The appointment, if on temporary employment, that is also qualified manner. So we don't come under the temporary employment category. Worship may kindly see the employment if on temporary employment, on temporary basis. It is a qualified clause, my lord. If the appointment is on temporary basis, apart from the fact that this clause is invalid.
Like a general clause.
It's just a general clause, my lord. Would your lordships have any further queries for me? Then may I conclude for the moment, my lords?
We have to fix it some other day.
Pardon me, my lord?
We have to fix it some other day.
Or otherwise, if your lordship pleases to extend a few minutes, then I can conclude. Because I've also produced the gist of the case. So based on that, and some few reply to my learned friend.
But you have to tell us a few minutes would be how much? Even 100 minutes can be.
If your lordship be gracious, then 30 minutes, or if not 20, I can finish within 20 also.
You
Hmm. Nine, tomorrow, tomorrow. No, 4 days, plus.
Okay.
Lordship, can I give you the lordships the bullet points in the other case? Same thing, same arguments. The bullet points in the other case.
Any difference in facts?
Fact is he had the 2013 appointees.
Okay.
Common judgment. Common
Better to
judgment.
give. Better give it.
Otherwise the same, my lords.
Yes.
Just the year of appointment is different, otherwise the same.
Then lordship may come to WA 24 of 2024.
Yes.
Yes. Here the G's are number 1. On the basis of the number of posts sanctioned by Government of India, the two centrally sponsored schemes Sarva Shiksha Abhiyan and Rashtriya Madhyamik Shiksha Abhiyan, the cabinet created 4,062 posts for SSA and RMSA. The page number 2. 3,404 posts were notified and 3,334 posts were advertised. These posts were under SSA and RMSA were to be coterminous with the scheme. 3. The present writ appeal number 24 of 2024 pertains to 2010 graduate teachers SSA batch in some of the districts of Nagaland. The writ appeal number 23 of 2024 pertains to 2013 graduate teachers SSA and RMSA batch in some of the districts of Nagaland. 4. By advertisement dated 20.
But we have a query here.
Lordship?
We have a query here.
Okay.
Please come to page 456. That the argument of Mrs. Young was this was not under the SSA scheme.
Yes, yes,
It was a
Lordship.
government.
So the advertisement also, we have clearly mentioned post creation, that is under SSA, Lordship. The advertisement also clearly mentioned the creation of posts, that is under SSA. Applications are invited from indigenous inhabitants of the state for filling up posts of graduate teacher and primary teacher in the government middle school and primary school under the Department of School Education, Government Nagaland, created wide notifications such as such. SSA, Your Lordship, you can see the notification number dated such and such as indicated in Annexure 1 to the recruitment shall be done as per the norm. This advertisement pertains to the subject of mathematics, science, and English.
But then why would you say that you are creating, filling up the post of graduate teachers and primary teachers in the government middle school?
Yes.
If it is under the scheme, normally you won't make them appointment under the government. You always say that you are appointed under the scheme and sent to that school.
So, Your Lordship, if we go through the points which I have mentioned, then that will make it more clear about your query.
Because in this connection, he is also referring to cross-linking this to page 725 and 726. It's okay. You will address that. On this one.
Yes, and Lordship, even for the other, some of the other districts also, they filed the repetition. Even the primary teachers also, they filed the repetition challenging their encadrement. But the learned single judge has dismissed the repetition. They are not before this court. Only this group of petitioners are before this court, Lordship. So, Lordship, number 4, by advertisement dated 2011-2009, the post of graduate teacher and primary teacher in... Yes.
Yes.
The post of graduate, point number 4, by advertisement dated 2011-2009, the post of graduate teacher and primary teacher in mathematics, science, and English were advertised. The advertisement specifically mentioned the created post under SSA VITE number such and such. 5. Appointment orders were issued in 2010. The appointment orders of the petitioner clearly mention that they are appointed under the created post of SSA with the conditions amongst others that 1. The pay and allowance of the appointee shall be borne by the State Mission Authority SSA. 2. In the event of discontinuation of SSA program, their pay and allowances shall be borne by the state. 6. The teachers of SSA, RMSA 2010 and 2013 batches demanded they be mainstreamed into the school education cadre of the state government. 7. Based on the recommendation of the committee headed by the Chief Secretary constituted to study the nature of the recruitment and appointment of these categories of teachers, the State Cabinet in its decision on 5/10/2013 agreed in principle to mainstream SSA and RMSA teacher of 2010 and 2013 batches into the state education cadre. 8. The PNR department accorded clearance and finance department accorded concurrence for the mainstreaming. The cabinet approved mainstreaming of SSA, RMSA 2010 and 2013 batches, qualified and trained teachers into the state cadre on 21/4/2022, and the mainstreaming of 2,292 educationally and professionally qualified teachers was notified on 2/9/2022. That the seniority of the 2010 SSA batch and the 2013 SSA and RMSA batch shall be parked immediately below that of the teachers already appointed on regular basis or whose service have regularized. 9. The appellants were appointed under SSA scheme and were brought into the state cadre with effect from 1/4/2022 by notification such and such dated 2/9/2022. Then, the Seniority of Graduate Teacher published Vide OM dated 9/2015 was quashed and set aside by this Honorable Court by common judgment and order dated 1/9/2017, passed in WPC number 214/2015 and WPC 34/2016, and directed the state respondents to rearrange the Seniority of Graduate Teacher. 11. The state judgment was upheld by the division bench of this Honorable Court by judgment and order dated 12/12/2019, passed in WA number 17/2017, to rearrange the Seniority of Graduate Teachers. Accordingly, in compliance with the order dated 12/12/2019, the final graduate seniority list as on 1/9/2022 was notified via notification dated 27/9/2022. This seniority list of graduate teacher is the first phase, which includes only the teachers appointed, recruited before 2009 with the sole purpose to fill up those vacant assistant headmaster, headmistress posts at the earliest by the eligible senior-most graduate teacher. 12. The petitioner have full knowledge of the appointments made against the SSA created posts for which the petitioner had the apprehension that they would not be included in the seniority list of graduate teacher of the school education department and for which the sought RTI information under RTI. The RTI reply was given on 3/9/2016, which was in tune with the conditions mentioned in the appointment orders of the petitioner that in the event of discontinuation of SSA program, their pay and allowances shall be borne by the state. The query raised by them. What about the service security validity of the teachers appointed against SSA posts? So your lordship say, even the petitioner then know that they are under the SSA post, so they ask question, what would be the security of the teachers appointed against the SSA created post? Will their service continue even after the project is over or ended? Then our answer is, mention may be made that post creation is not done by the SSA. Lordship, you know that post will be sanctioned by the central government, but it is the SEC who has to create the post, Lordship. It is not done by the SSA, it is a government of Nagaland undertaking. Hence, teachers are appointed on a regular basis and the services is not coterminous with the SSA project. Because in the appointment order, we say that once the project ends, we will abort their salary, Lordship. 13. The petitioners were brought into the state cadre only on 21/4/2022. Therefore, the question of restoring the seniority with effect from the initial appointment, that is 2010, does not arise. It is a settled principle of law that a person cannot be given seniority prior to his birth in a cadre. Number 14. The posts held by the petitioners were created under centrally sponsored scheme, that is SSA, and salary support was provided under CCS SSA. 15. There is no illegality or perversity in the common judgment and order dated 10/6/2024, passed by the learned single judge in WPC number 279/2022 and WPC 278/2022, and no interference of this honorable court is warranted. The learned single judge has taken note of the judgment of Supreme Court in Dhyan Singh and others v. State of Haryana and others, reported in 2002-10 SCC 656 and Parmeshwar Nanda and others v. State of Jharkhand through Chief Secretary and others, reported in 2020-12 SCC 131, that engagement of an employee under a specific scheme cannot be held to be an employment under any establishment of the government, inasmuch as employment under such scheme cannot be treated to be a part of the formal cadre of the government. 16. The learned single judge came to the right finding that the posts were created under SSA and RMSA, which are centrally sponsored scheme. The salaries were to be paid out of the funds of central government, and it was only if the said scheme were discontinued, the government of Nagaland would have paid it from its coffer. 17. The learned single judge reasonably applied the ratio laid down in Dhyan Singh Supra and Parmeshwar Nanda Supra that the petitioner cannot be regarded as having entered into the state education cadre of the government of Nagaland till the notification was issued on 2/9/2022, wherein they were brought within the service of the state education cadre of the government of Nagaland with effect from 21/4/2022. The petitioner's interstate seniority have to be taken into account on the basis of the SIC notification dated 1/9/2022 and for which the impugned notification dated 27/9/2022 cannot be interfered with. That is the final graduate seniority list as on 1/9/2022. Lordship, my learned friend has mentioned has relied so much heavily on that earlier decision passed by this court, Your Lordship. The early decision pertains were challenged only the seniority release. It is not in regard to the determination of the service. At that point of time, Your Lordship, the stake, we have made a mistake. We have included them in that seniority list. But that seniority list was questioned set aside by this court. So when it is questioned set aside by this court and directed us to rearrange the seniority list, for which we brought the 2022 graduate seniority list, which does not include the petitioner, Your Lordship. It includes only those graduate teachers who were appointed before 2009, Lordship. So when the challenge the graduate seniority list of 2022, the learned single judge did not interfere in that, because they became stake gather only on 21/4/2022, Lordship. And my learned friend has also said that some of the petitioners, they have enjoyed the MSCP. Lordship, even my statement has also been recorded in the learned single judge judgment that the MSCP, some MSCP was granted erroneously by mistake. So the learned single judge has come to the finding that a mistake cannot give a right to the petitioner, Your Lordship, does not give them, treated them to be a regular employee. Then, Lordship, with regard to the subsequent development, Lordship, where my learned friends have filed the additional affidavit, those were in regard to the notifications where we confirmed some of the appellants from the date of the initial service, but that was a mistake for which we have made a corrigendum. So again, that corrigendum they have annexed in their additional affidavit also, Lordship. Yes. And it does not include all the petitioner. Only some of the petitioner, by erroneously, we have made a mistake. So, Lordship, when if we see the post creation, the advertisement, the appointment, it clearly mentions about the SSA and RMSA posts, and were appointed under the centrally sponsored scheme. They have been demanding, they have been protesting, Your Lordship, to gather them, for which we had gathered them with effect from 21/4/2024. So, Lordship, there is no perversity in the learned single judge judgment. It is a sound judgment, so no interference may be called for. That is my submission. Much obliged.
Lordship, the other bullet points in the other case, just the case number in the previous case will differ. I've corrected that, my lord. And they were the petitioners, the appellants here were the petitioners. At page 29 of the memo of appeal, in the other rate appeal, my lord, in a memo of appeal, page 29, paragraph 3.
We noted that 1, 10, 30, 31, 36, 38.
No, my lord, that is the rate appeal 24. In the other rate appeal, no one. In the other rate appeal, which we have not referred to, but same bullet points, more or less the facts are the same. Just numbers will change. That's all. So they were the persons in this rate appeal who were the writ petitioners in WPC number 172K, which was disposed of along with 121K. That I have mentioned in paragraph 3 at page 29. Common judgment on the matter.
You've indicated in your bullet point.
Yes, madam. This portion I have pardon my lord. This particular part I forgot to mention. So this may be kindly noted, my lord. The appellants who were the writ petitioners in WPC number 172K of 2017. Their numbers are mentioned in paragraph 3, page 29 of the memo of appeal.
Petitioner WPC
WPC number 172K of 2017. 170K and 172K. All these were disposed of by a common judgment, along with 121K.
This is 152.
This is
72.
172, 170 and 172.
Appellants were petitioners in WPC 170 and 170.
Yes, my lord. I've mentioned the numbers in paragraph 3, page 29.
Paragraph 3.
Yes, my lord. Paragraph 3, page 29 of the memo of appeal.
Raising over and counsel for the appellants. You say it like this: the submissions of Mr. Izimami, learned counsel for the appellants, please be circulated on it. Additional Advocate General for the respondents is concluded. Judgment is out.
Much obliged, my lords.
Mrs. Gomi and Madam Shubhari, just a word with you, in the chamber.
With me, my lord?
Both of you.
Very well, my lord.
Separately, because this is too big. The affidavits in a separate file, it will be better. Both the cases, the conduct is going different, and the affidavits and this argument can be different. It is easier to handle than. We'll do that.